Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste.
Oath or affirmation, announcements by the Speaker.
Honorable members, I have received communication from the Honorable Major General Retired Edmund Dillon, MP, Member for Point Forte, the Honorable Sherian Critchlow Coburn, MP, Member for Lupino Bonnier West, Dr. Tim Gopi Singh, MP, Member for Caroni East, Mr. Ganga Singh, MP, Member for Shogunas West, and Mr. Prakash Ramadan, MP, Member for St. Augustine, who have requested leave of absence from today's sitting of the House. The leave which the members seek is granted.
Bills brought from the Senate, petitions, papers.
The Minister of Finance.
Thank you, Madam Speaker. I have the honor to lay the following papers: the report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Police Complaints Authority for the years ended September 30th, 2017 and 2018. That's papers 1 to 2. 3, the report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Office of Procurement Regulation for the year ended September 30th, 2018. 4, the annual report and audited financial statements of the Trinidad and Tobago Securities and Exchange Commission for the year ended September 30th, 2018. 5, the audited financial statements of the Sports Company of Trinidad and Tobago Limited for the financial year ended September 30, 2019. 6, the annual report and consolidated or audited financial statements of the First Citizens Investment Services and its subsidiaries for the year 2019. 7, the annual report of the Financial Intelligence Unit of Trinidad and Tobago for the year ended September 30, 2019. Madam Speaker, I beg to move that papers 1 to 4 be referred to the Public Accounts Committee and papers 5 and 6 be referred to the Public Accounts Enterprise Committee.
Honorable members, the question is that papers 1 to 4 be referred to the Public Accounts Committee and papers 5 and 6 be referred to the Public Accounts Enterprises Committee. All in favor say aye. Any against? The ayes have it. Leader of the House.
Thank you, Madam Speaker. Madam Speaker, I have the honor to lay papers 8 and 9, the ministerial responses to the 11th report of the Joint Select Committee on Social Services and Public Administration on a follow-up inquiry into the effectiveness of the state's interventions directed at socially displaced persons. The responses are from the Ministry of Social Development and Family Services and the Ministry of Health. Papers 10 to 12, papers 10 to 12, the ministerial responses to the 12th report of the Joint Select Committee on Social Services and Public Administration on an examination of the current level of childhood obesity and the state's interventions to promote a healthy lifestyle among children. The responses are from the Ministry of Health, the Ministry of Education, and the Ministry of Sport and Youth Affairs. Paper 13, the response of the Trinidad and Tobago Police Service to the 7th report of the Joint Select Committee on Finance and Legal Affairs on an inquiry into the wider application on non-custodial penalties in the criminal justice system of Trinidad and Tobago. Papers 14 and 15, the responses of the 19th report of the Public Administration and Appropriation Committee on the examination of the expenditure and internal controls of the Ministry of Works and Transport. The responses are from the Service Commissions Department and the Ministry of Works and Transport. Thank you very kindly, Madam Speaker.
Committees, Prime Minister's questions, urgent questions.
Member for Mayaro.
To the Minister of National Security, given threats by the Lifeguard Association to withhold services at the Mayaro Lifeguard Station due to the dilapidated state of the facility for the upcoming Carnival weekend, could the Minister indicate what urgent remedial action is planned to resolve this?
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, what is happening is that the Ministry of National Security is working with the Ministry of Public Administration. Initially, a building was identified that would have been suitable. It is being used currently as government traveling quarters. We've now been told that it is currently in use, and what has been happening is a negotiation for another building. My understanding that all that is outstanding at this stage is the agreement of rent. They're $3,000 apart on the rental amount, and instructions have been given to ensure that the lifeguards have adequate accommodation way before the Carnival weekend.
Member for Princestown.
Thank you, Madam Speaker. Madam Speaker, through you to the Honourable Minister of Public Utilities, could the Minister indicate why the Water and Sewerage Authority has not been keeping with its scheduled supply of water for Tableland in the past 2 months?
Minister of National Security.
Repeat his question. No,
I'm sorry, it's Minister of Public Utilities.
Thank you very much, Madam Speaker. Madam Speaker, the people of Tableland is supplied water via the Navet Dam, which is presently operating at 70% capacity, i.e. 40 million gallons of water a day as opposed to its capacity of 20 million gallons of water a day. Additionally, the network of pipes servicing Tableland and surrounding districts are over 70 years old, and due to the size and porous nature, is inadequate to reliably supply the area. Madam Speaker, that being said, Madam Speaker, I have been advised by officials at WASA that this area receives a scheduled 1 day a week, a scheduled supply of water 1 day a week, which has been in place for a very long time. Madam Speaker, based on the information provided to me by WASA, the people of Tableland are in receipt of this 1 day a week supply. There have been interruptions over the last 2 months based on the porous nature of the pipes, and which have been fixed quickly by WASA, and as such, even if the days had to be changed, they have been able to give them back their 1 day supply. The solution to the Tableland issue, like the solution for a number of areas, is the replacement of over 15 to 20 kilometers of pipe along the Naparima-Mayaro Road. This project is presently under consideration in our comprehensive plan for the water sector of Trinidad and Tobago. When completed, based on the volume of water out of Navet, the people of Tableland and surrounding areas could expect an improvement in their water supply to about 4 to 5 days a year.
Supplemental, member for Princestown.
Thank you, Madam Speaker. To the Honourable Minister, in light of the answer that you have provided, could you indicate the timeline that you're looking at in terms of making a determination of when this project could possibly commence?
Minister of Public Utilities.
Madam Speaker, as I said, this project, in addition to a number of projects to change a lot of pipelines, this particular project it has an estimated cost of somewhere in the vicinity of over $70 million. This project is being looked at in the context of a number of other projects to comprehensively look at it. We are looking at long-term solutions to deal with the water situation in Trinidad and Tobago, and we will be looking at it in addition to a number of other projects expeditiously.
Questions on notice?
Leader of the House.
Speaker. Madam Speaker, there are no questions for oral response. There are 4 questions for written response, and the government has the answer to all 4 responses, which we will pass to the clerk.
Whip.
Madam Speaker, I just want to draw your attention. I'm seeking clarification. The Chamber was in session, Parliament in session, and the Prime Minister maybe unknowingly walked down the aisle. And it happened in the last session where that happened, and one of our members, and he was made to apologize to the Chamber.
Leader of the House.
Madam Speaker, I was suffering from miscustom. I unreservedly apologize for crossing there. I'm running in late. I literally lost my sense of geography. Seeing my colleague on her feet, I was focusing on not passing behind her while she was on her legs, and caused me to walk there. Madam Speaker, since that is the biggest issue in the opposition, I humbly apologize to all my colleagues and those on this side and to the nation.
Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Princestown.
Thank you, Madam Speaker. Madam Speaker, through you, in accordance with Standing Order 17 of the House of Representatives, I hereby seek your leave to move the adjournment of the House today, Friday, February 7, 2020, for the purpose of discussing a definite matter of urgent public importance, namely, a crisis created by the Ministry of Public Utilities in South Trinidad due to the total absence of reliable and regular supply of pipe-borne water to the constituencies of Princestown and Moruga-Tablan for the past month through WASA. The matter is definite because it pertains to the current situation faced by the constituents of Princestown and Moruga-Tablan over the past month, who are being denied this vital commodity in their areas. It is urgent because water is an essential part of the survival of human beings for the preparation of meals, the practice of proper hygiene, the conduct of household duties, and personal consumption. It is of public importance because it will negatively affect the health and lives of the citizens in these constituencies, and seeing that there are no alternative safe water supplies provided by the ministry. I so move. Thank you, Madam Speaker.
Honourable members, I am not satisfied that this matter qualifies under the standing order. It would not have escaped your attention that a question was allowed under urgent question pertaining to this matter. Member for Kamuto Mansinilla.
Thank you, Madam Chair. Madam Chair, I hereby seek your leave to move the adjournment of the House at today's sitting for the purpose of discussing a definite matter of urgent public importance, namely, the urgent need for the Ministry of Social Development and Family Services to intervene and investigate into the operations of the Cyril Ross Children's Home. The matter is definite as there have been numerous complaints regarding the transparency and accountability of operations at the Cyril Ross Children's Home, with many of its children ending up on the streets, especially within the capital city with nowhere to go. The matter is urgent because their physical, mental, emotional, and psychological well-being go untreated and unchecked, especially those children who were in receipt of antiretroviral medication. The matter is of public importance as it calls for additional state resources in healthcare and social services, without which the resulting scenario is one which impacts the country's overall growth and development. I so move.
Honorable members, I am not satisfied that this matter qualifies under this standing order. I advise that the member pursues this matter under Standing Order 16.
Statements by ministers.
Leader of the House.
Madam Speaker, I seek your leave to move the suspension of the standing order. Sorry, and that is Standing Order 45-1 in relation to statements by ministers to allow the Prime Minister to make a statement of national importance.
The leave is sought is granted, and therefore I will now put the question.
Very kindly, Madam Speaker. Madam Speaker, I beg to move the suspension of Standing Order 45-1 in relation to statements by ministers.
Honorable members, the question is that Standing Order 45-1 be suspended in regard to the statement by ministers to allow the Prime Minister to make a statement of national concern. All in favor say aye. Aye. Any against? The ayes have it. Prime Minister.
Madam Speaker, I have been authorized by the Cabinet to make the following statement to this Honorable House. Madam Speaker, in 2007, the Government of the Republic of Trinidad and Tobago and the Government of the Bolivarian Republic of Venezuela executed a framework treaty relating to the unitization of hydrocarbon reservoirs that extend across the general framework. Madam Speaker, could I not be disturbed by my colleagues on the other side, please?
Please proceed, Prime Minister.
Thank you. And may I, Madam Speaker, for the benefit of the population, may I restart, please? In 2007, the Government of the Republic of Trinidad and Tobago and the Government of the Bolivarian Republic of Venezuela executed a framework treaty relating to the unitization of hydrocarbon reservoirs that extend across the delimitation line between Trinidad and Tobago and Venezuela. The treaty established the general framework under which any cross-border reservoir would be exploited. It obliged the parties to conclude specific unitization agreements for the exploitation and development of cross-border hydrocarbon reservoirs within the unit area. In this regard, Madam Speaker, the treaty provided for the establishment of a joint ministerial commission and a steering committee to facilitate the implementation of the treaty. Pursuant to the terms of the treaty, the cross-border reservoirs were to be exploited and developed as a single unit, with determination of the area and allocation of hydrocarbons by a reservoir technical working group comprising representatives of the exploration and production companies and the resource owners. A unit operator was to be appointed from the companies, subject to the approval of the parties, to develop the cross-border hydrocarbons within the unit area. Cross-border hydrocarbon reservoirs exist within 3 fields, which are found on the southern and northern continental shelves between Trinidad and Tobago and Venezuela, respectively. These fields are Loran Manatee, the Manikin Coquina, and Kepak Dorado. Madam Speaker, the first of cross-border fields to be considered for unitization on the basis of the terms established in the framework treaty was the Loran Manatee field. The Loran Manatee is a shallow water field that straddles the maritime boundary of Trinidad and Tobago and Venezuela, which forms a single cross-border unit between the countries. The Loran Manatee field comprises a surface area of 209.42 square kilometers, which comprises Block 2 of the Venezuelan Plataforma Deltana, with a surface area of 169.07 square kilometers, and a part of Block 6D in the southwest marine area of Trinidad and Tobago, with a surface area of 48.35 square kilometers. Exploration activity, initially by state-owned Petróleos de Venezuela, PDVSA, and later by U.S. corporation Chevron, which held a 60% interest, encountered a substantial amount of gas in the Loran field. In 2005, Chevron and British Gas, which held a joint interest of 50% each in the Block 6, comprising Subblock 6B and Subblock 6D, discovered the Manatee field in the Block 6D. Subsequent technical evaluation by a reservoir technical working group comprising representatives of Chevron, British Gas, which is now Shell, PDVSA, and the Ministry of Energy and Energy Industries ascertained that the fields were integrated. Chevron subsequently sold its interest in Block 6 to Shell, which now has 100% interest in the block on the Trinidad and Tobago side. Following negotiations by the parties, Madam Speaker, a unitization agreement for Loran Manatee was prepared and accepted by both governments. In this regard, in August 2010, Cabinet agreed that the Republic of Trinidad and Tobago participate with the Bolivarian Republic of Venezuela in the exchange of instruments of ratification in respect of the Framework Treaty and the execution of field-specific Loran Manatee Unitization Agreement. Madam Speaker, on August 16, 2010, the government of the Republic of Trinidad and Tobago and the government of the Bolivarian Republic of Venezuela exchanged instruments of ratification of this framework treaty, which action officially brought the treaty into force. This facilitated the execution of the field-specific Loran Manatee Unitization Agreement on August 16, 2010. The Reservoir Technical Working Group, appointed by the parties, established the gas in place in the Loran Manatee field at approximately 10.07 trillion cubic feet, of which 2.712 TCF, or 26.94%, is within the maritime area of Trinidad and Tobago, and 7.357 TCF, or 73.06% within the maritime area of Venezuela. Madam Speaker, in accordance with the provisions of the Loran Manatee Treaty, a ministerial committee and a steering committee were established in order to facilitate the implementation and execution of the treaty and related agreements. Under the direction of the committees, a unitization and unit operating agreement was developed for the exploitation and development of the Loran Manatee field. However, progress in the development of the field has now been curtailed in that way by the sanctions imposed by the United States government, which block United States companies from doing business with PDVSA. This came about, Madam Speaker, in January, early 2019. This impacts on the ability of Chevron, an American company in particular, to participate in any development of the Loran Manatee field. This is of concern to both the government of the Republic of Trinidad and Tobago and the government of the Bolivarian Republic of Venezuela. As a consequence of this 2019 negative geopolitical development, the government of the Republic of Trinidad and Tobago and the government of the Bolivarian Republic of Venezuela agreed to undertake the separate and independent exploitation and development of the Loran Manatee field. Pursuant to that decision, Cabinet agreed to the following. 1, the rescission of the unitization agreement for the exploitation and development of hydrocarbon reservoirs of the Loran Manatee Field that extends across the delimitation line between the Republic of Trinidad and Tobago and the Bolivarian Republic of Venezuela, and this dated August 16, 2010. 2, the agreement between the government of the Republic of Trinidad and Tobago and the government of the Bolivarian Republic of Venezuela for the independent development of the cross-border field, the Loran Manatee, known as now the agreement. In accordance with Article 7.3 of the Loran Manatee Unitization Agreement dated August 16, 2010, an official notice of termination of that agreement was issued by the government of the Republic of Trinidad and Tobago to the government of the Bolivarian Republic of Venezuela. This was followed by the execution of the agreement between the government of Trinidad and Tobago and the government of the Bolivarian Republic of Venezuela for the development of the cross-border field, the Loran Manatee. The agreement was executed on October 15, 2019. Accordingly, the unitization agreement has been terminated and will have no further force or effect. It has been replaced by a new agreement between the countries which allows for the separate and independent exploitation and development of the Loran Manatee Field. Under the terms of this new agreement, the Republic of Trinidad and Tobago and the Bolivarian Republic of Venezuela have the right to develop its own share of the hydrocarbon reservoirs within the Loran Manatee Field based on a recovery factor of 69% of the estimated gas in place of 10.07 TCF. Trinidad and Tobago, therefore, can produce up to 1.872 TCF, and Venezuela can produce up to 5.076 TCF from the gaseous hydrocarbons in place. The volumes of gaseous hydrocarbons initially in place, the average percentage of original gas in place for each party, and the assumed recovery factor may be adjusted based on any new data arising from a redetermination of the gas in place. Madam Speaker, a redetermination may be undertaken after 1 year, but not later than 3 years from the date of first production by either party, and such other intervals, if such request is made, at least 2 years after the most recent determination. Madam Speaker, this decision to allow each party to independently develop its share of the field will accelerate its development. The agreement provides for the development of reservoirs within the Loran Manatee Field by the exploitation and production companies authorized to undertake such activities in accordance with their respective agreements with the relevant party. Pursuant to the terms of Block 6 Production Sharing Contract, in which the Manatee Field is located, the contractor, Shell, will be required to prepare and submit for the Minister's approval a work program and budget for the contract area encompassing the Manatee Field, setting forth the planned exploration and development activities. Shell has already agreed to undertake and accelerate these requirements. As regards to this disposition of hydrocarbons produced from Subblock 6D, the Manatee development, the contractor, Shell, is to submit a written request to the Minister to initiate negotiations to agree on contract terms in order to commence the appraisal and pre-sanction activities necessary to progress the commercial development of the Manatee Field. Shell has initiated preliminary discussions with the government of Trinidad and Tobago and is working on various development scenarios for early on-stream gas production of the field. It is projected, Madam Speaker, that gas production could commence in the 2025 period at rates ranging from 270 million standard cubic feet per day to 400 million standard cubic feet per day. Madam Speaker, natural gas from Loran Manatee, or now to be known as the Manatee field, was not initially factored in the government's gas production forecast, but in light of these far-reaching agreements, can now be added as significant reserves to sustain the levels of gas consumption at Point Lisas. This development will therefore augment gas production from 2025 and assist in alleviating gas curtailment that has been a worrying issue for the downstream industry and, I dare say, the national economy of Trinidad and Tobago. Madam Speaker, this agreement sets a precedent for further cooperative development on the other smaller but very significant cross-border fields, the Manakin, Copina, and Cape of Dorado, in which Trinidad and Tobago has almost 1 TCF of available resource. A unitization agreement was executed on the Manaki Coswina on February 24, 2015, and the draft agreement has been prepared for Cape of Dorado. It is estimated that 0.85 TCS, or 850 billion cubic feet of natural gas, are located within the Trinidad and Tobago maritime area of these two cross-border fields. Loran Manatee Field Agreements is a landmark decision in the country's cross-border relationship and a major policy shift in the government's gas development strategy. It is further testimony of positive initiatives being undertaken by the government of Trinidad and Tobago to meet critical domestic gas requirements for a competitive energy sector and to maintain our position as a major player in the global petrochemical and energy business. Madam Speaker, contrary to some disappointing but nonetheless predictable negative media headline reports, the dismantling of the Loran Manatee Unitization Agreement is beneficial to Trinidad and Tobago. The previous attempt to extract gas from Loran Manatee field has been going on for 20 years without any real progress to show for it. Madam Speaker, however, as it is said, necessity is the mother of invention. And we, having not invented, have successfully found a way to develop our proven resource, to partner with an oil and gas major, in this case Shell, to get the long dormant field developed and infrastructure built with the outcome, in the medium term, being gas flowing from these fields on our southeastern border to our national economy at Point 14 and at Point Lisas. Madam Speaker, let me once and for all clarify for the average citizen our early initiative, which is commonly and even derisively referred to by some as the Dragon Deal. Madam Speaker, whereas Loran Manatee Field is in the southeast of our country and involves a gas field which is shared by Trinidad and Tobago and Venezuela, the Dragon Field, which is located on the northwest of Trinidad, lies entirely within Venezuelan territory and is owned by the people of Venezuela. Our only interest in this Dragon Field is wholly commercial and entirely dependent on possible commercial arrangements. Very early in the life of this administration, we took steps to open up these commercial possibilities to allow Trinidad and Tobago industries to have access to a larger pool of raw material resources. The Dragon Initiative, when completed and operationalized, will also be beneficial to Trinidad and Tobago. The deal is still on, but has been prevented from formally moving forward at this time by trade restrictions imposed by the United States government on Venezuela. This is a development over which, Madam Speaker, May I be allowed to speak in silence?
Members, the Prime Minister will be heard in silence. Prime Minister, please continue.
Thank you, Madam Speaker. It is not my intention to irritate any person in this House, Madam Speaker. As I was saying, Madam Speaker, the Dragon initiatives, whenever completed and operationalized, will also be beneficial to Trinidad and Tobago. The deal is still on, but has been prevented from formally moving forward at this time by trade restrictions imposed by the United States government on Venezuela. This is a development over which we had nor now have any control, but any ultimate outcome will always be one of mutual benefit to all the people of Trinidad and Tobago and all the people of the Bolivarian Republic of Venezuela. The genesis of the project was bilateral discussions in April 2016 between the government of the Republic of Trinidad and Tobago and the Bolivarian Republic of Venezuela. This led, excuse me, Madam Speaker. This led to the execution on May 23, 2016, of a Memorandum of Understanding for the technical and commercial studies related to the natural gas supply. And this was signed between the Bolivarian Republic of Venezuela and the Republic of Trinidad and Tobago. The objective of the MOU was to set the general conditions for the execution of a technical economic feasibility study of the natural gas reserves in fields located in the northern and southeastern areas of the continental shelf of the Bolivarian Republic of Venezuela, and the assessment of the feasibility of developing a gas interconnection between the Republic of Trinidad and Tobago and the Bolivarian Republic of Venezuela. This is an initiative which was welcomed by all the right-thinking people of our country and all our neighbors. It summarizes neighborly cooperation in our zone of peace and prosperity, which we hold out to our children and grandchildren. Technical teams from both countries were appointed to evaluate the feasibility of the supply of gas, and in particular, the Dragon field from Venezuela to Trinidad. Following a successful review of the project, a government-to-government agreement on the implementation of a gas interconnection project between the Republic of Trinidad and Tobago and the Bolivarian Republic of Venezuela was finalized. This agreement was signed in Caracas on the visit of the Prime Minister of the Republic of Trinidad and Tobago and President Maduro on December 5th, 2016. On January 15, 2017, a heads of agreement was executed among NGC, Venezuelan state-owned PDVSA, and Shell for the extraction of gas from the Dragon field for supply to domestic and LNG industries in Trinidad and Tobago. Madam Speaker, for some strange reason, that historic development displeased some people within our border. Madam Speaker, first gas was projected for 2023 at an initial production rate of 330 million standard cubic feet per day, increasing to 500 million standard cubic feet per day at peak production. A term sheet which sets out the commercial terms for the project has been finalized and agreed by the participating entities, NGC, PDVSA, and Shell. Discussions commenced on the terms of a gas sales agreement. However, further progress has been stymied by US trade sanctions, which have escalated and which target transactions with PDVSA. Notwithstanding, Madam Speaker, the government of the Republic of Trinidad and Tobago and the government of the Bolivarian Republic of Venezuela are continuing our collaboration on the premise that the trade restrictions on Venezuela will be lifted sometime in due course. Madam Speaker, the action by the government in these matters is a clear indication of our commitment and resolve to attain a sustainable domestic gas industry. We are on the right track, Madam Speaker, as the positive results show that we are getting the job done. I thank you, Madam Speaker.
Member for Caroni Central.
Thank you very much, Madam Speaker. Just one question, Honorable Prime Minister. Will the financing of the project involving the Lorraine Manatee Field be done by Shell or by Shell and the government of Trinidad and Tobago?
Prime Minister.
Madam Speaker, there was a time when we could have answered that question with a smile on our face. But as you would have heard earlier, Madam Speaker, that the $16 billion at NGC, which was aimed at financing this kind of development, were frittered away by the last government, and now NGC has no money. NGC has no money to invest like this, but if it is required for NGC to borrow to take part in it, we will, and we have an undertaking from Shell that the financing would be available from Shell.
Introduction of bills. Motions relating to the business or sittings of the House are moved by a minister. Public business, committee business, motions.
Member for Digo Martin, Northeast.
Thank you, Madam Speaker. Madam Speaker, I beg to move the following motion standing in my name. Be it resolved that this House adopt the report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016. Just 1 second, Madam Speaker. Madam Speaker, this bill has had a long and tortuous history, the bill that forms part of this report. When one looks at the history of various attempts by governments to amend our legislation relating to gambling and betting, one sees that as far back as 1999, there was a gambling and betting amendment bill laid in this House. That bill subsequently lapsed on the dissolution of Parliament to make way for the 2000 election. So that bill never saw the light of day. In 2001, when the very short-lived UNC government returned for a small period, another bill was laid in September 2001, an amendment to the Gambling and Betting Act. That lapsed 1 month later when that UNC government crashed out of office in 2001. In 2015, just before our predecessors also crashed out of office, on the 22nd of May 2015, a bill entitled the Gambling, Gaming and Betting Control Bill 2015 was laid 22nd of May 2015, lapsed on the 17th of June 2015 when the Parliament was dissolved. So that there have been attempts to reform our gambling and gaming sector since 1999. But all attempts by previous administrations have met with no success. In 2016, this administration relayed the identical bill, the Gambling, Gaming and Betting Control Bill 2015, the exact same bill that had been laid by the former administration. We laid it in 2016, word for word. We didn't change a full stop or a semicolon. And this bill was eventually sent to a joint select committee. in February of 2017, a joint select committee was established. The members of that committee were myself as chairman, Mr. Al-Rawi, Mr. Young, Ms. Oliver, Mr. Singh, Mr. Indarsingh, Ms. Ramkisoon, Mr. Cummings, Mr. Coppin, Mr. Mark, Ms. Gopi Schoon, and Mr. Richards. So in 2017, a committee was established. The committee first met on February the 13th, where that was a procedural meeting, and then the committee met on the 21st of February 2017, the 13th of March 2017, the 5th of April 2017, the 26th of May 2017, the 5th of September 2017, the 6th of September 2017, and the 13th of September 2017. So the committee met on numerous occasions in 2017 and reported to Parliament during that period. It was agreed by the committee that there should be the participation of stakeholders, so that the committee sought and obtained written submissions from the Central Bank of Trinidad and Tobago, the Bankers Association of Trinidad and Tobago, the Trinidad and Tobago Manufacturers Association, the Trinidad and Tobago Members Club Association, the Betting Levy Board, the Union of Member Clubs and Lottery Workers, Financial Intelligence Unit of Trinidad and Tobago, the Board of Inland Revenue, the Integrity Commission of Trinidad and Tobago, Commission of Police, Custom and Excise Division, Trinidad and Tobago Racing Authority, Hammersmith Attorney at Laws, Royal Princess Casino Royal Club, Mr. Defoe for the Grace Connection, Chico Enterprises, Ms. Nunez for Ion Dependency, Duces Private Members Club, Amusement Gaming Association, Mapau Members Club, and also some members of the public, Mr. Suklal, Mr. Ramnarain, and Ms. Ramsingh, Ms. Espinoza, Mr. Jackson, Mr. Sukram, and Mr. Pariag. The committee then held discussions with a number of stakeholders, including Bankers Association, Financial Intelligence Unit, Central Bank, Members Club Association, Integrity Commission, Betting Levy Board, Mapau Members Club, Union of Members Club and Lottery Workers, Mr. Suklal, Trinidad and Tobago Racing Authority, Grace Connection, Ion Dependency, Princess Entertainment Corporation, Bookmakers Association, Association for Amusement Gaming Machines, Customs and Excise, Trinidad and Tobago Police Service. And during these meetings, these comprehensive meetings, a number of issues were raised with respect to a review of definitions and terms contained in the bill, the revisiting of the criteria of a fit and proper test of a person employed within the industry, issues relating to problem gambling, gambling addiction, etc., whether board members should be appointed by the line minister, the impact of the bill on the horse racing industry and amusement gaming industry, restrictions on horse racing, whether the responsibilities given to police officers in the bill should also be given to municipal police officers, the ability of operators in the racing industry to pay monies into the consolidated fund, sanctions, and so on. The committee also agreed an expert consultant was necessary, received 15 applications, and eventually the firm of Governance Associates was selected, they having no conflict of interest and they being world experts in this field. We went right through 2017 with this, and the Parliament was approaching prorogation, and therefore the matter was carried over into the 2018 session. We continued in 2018, we continued in 2019, and after years, we're talking from 2017 to 2019, years of consideration, meetings, consultation. We had video conferences with our experts. One was in Australia, one was in London, world experts in this industry. We Many questions were asked by members of the committee, including opposition members and independent senators, and answers were given to every question. In particular, Madam Speaker, we also prepared regulations. These regulations, and I want to deal with this immediately, because during one of the meetings, an opposition member who had dragged out the proceedings for over a year, insisting on consultation with all these people, that opposition member who had dragged out the meeting for over a year, said they want to see the regulations. And that opposition member was reminded that regulations were first circulated to members on Monday, the 13th of March, 2017, almost 3 years ago. Yes, 3 years ago. So 1 year after, or 2 years after the regulations were circulated to the members, a member, an opposition member, wanted to see the regulations, and of course accused us of not having any regulations. Stakeholders were informed on the 20th of March 2017 that the draft regulations were available on the Parliament's website, and they were asked to review, and when they came to be interviewed by the committee, to provide submissions on both the bill and the regulations. The members of the committee continued to question the regulations, so the committee expanded its work, forwarded the regulations to the international consultants for review and analysis, and we continued the committee into November 2019, so that in that meeting on 2019, we revisited the regulations again. We had been looking at these regulations by that time for 2.5 years. On the 15th of November 2019, the committee met by video conference with our international expert to go through every single regulation, and Mr. Clark, our consultant, made observations and put forward suggestions to strengthen the regulations. May I say at this time, Madam Speaker, that these regulations are for affirmative resolution, and therefore the bill will have to be passed first, and then we debate the regulations for affirmative resolution. And clearly, all parts of the bill cannot be proclaimed until the regulations have been debated and passed in this House. Now, let me go to the bill itself. I am advised, Madam Speaker, that notwithstanding the fact that we've been at this for 4 years, that members opposite, we have been at this for 4 years in a joint select committee.
Where everybody's there.
Everybody has participated. The opposition has participated. The independent bench has participated. We have had sessions in public. We have sessions in private. We have answered every single question. We have interviewed every single interested party. And we've been looking at regulations for almost 3 years. So, Madam Speaker, now let me present the Gaming and Betting Control Bill for the second time in this House. It's not the first time. There's been an urgent need in this country to update existing gambling legislation. This is well established, and you can see governments have been trying to do this since 1999. The gambling sector is currently governed by 4 distinct pieces of legislation, none of which have been able to keep up with the significant expansion in the sector, especially as it relates to the growth of private members' clubs, which are largely unregulated. I'm advised that Cabinet, as far back as 1996, when members opposite were in the government, made various policy decisions with the intention to prompt change in the regulation of the sector. However, none of these decisions made by that former administration in the 1990s bore any meaningful fruit. So it is this government that decided we would take the exact same bill laid by the previous government, word for word, and bring it back into this Parliament and go through the process of consultation, fine-tuning, refinement, and so on. These copious consultations, this 4 years of consultation, have enhanced the quality of the bill that is being laid today. I'm told that Trinidad and Tobago probably is the only country in the world that has an unregulated gambling sector of this size, according to the International Monetary Fund. We are the only country in the world that has an unregulated gambling sector of this size. The importance of the legislation is evident from its objects, which are in Clause 5, which include protecting minors and other vulnerable persons from being harmed or exploited by gambling, ensuring that gambling is conducted in a fair, open, and responsible manner, preventing gambling from being a source of crime, being associated with crime or being used to support crime, ensuring compliance with written laws for anti-money laundering and counter-terrorism financing, ensuring consumer protection, providing for the proper collection of taxes, and contributing to the economy by creating employment. As I indicated, this bill was first introduced on July 1st, 2016, and it is a carbon copy of a bill submitted by the other administration in 2015. Given the voluminous provisions within the bill, I do not propose to treat with each clause. Instead, I will discuss the important aspects of the bill and highlight the amendments recommended by the committee. The term betting was expanded to include events other than animal racing or sporting events. It would now include scenarios such as betting on economic indices, such as oil price, for example. The bill seeks to provide the Gambling Commission with the authority to review any matter connected with gambling licenses where key persons have been convicted of a criminal offense. The Commission also has power to revoke licenses in similar circumstances. The definition of key person was therefore introduced so that the reach of the Commission is clear. The Commission will have powers to verify the background, character, and reputation of an applicant for a gambling license, and any of their associates, employees, or relatives. The term relative was amended to widen the class of persons in respect of whom the Commission may conduct investigations. Clauses 6 to 30, which are in Part 2 of the bill, are administrative. They set out the objective of the Commission, its establishment, constitution, powers, and duties. It will be a body corporate, managed by a board, appointed by the President on the advice of the Minister. Persons will be considered for appointment to the board based on their experience in the gambling industry and other fields like law, finance, social work, law enforcement. Clause 6 provides for a category of persons who shall not be eligible for employment to the board, such as persons who operate gambling establishments, persons who have a financial interest in gambling establishments. Clause 13 of the bill imposes a duty on members of the board to submit an annual declaration that they have no actual or contingent pecuniary interest in any licensee or proposed licensee or any business carrying on business with the Commission. It will not be acceptable for a board member to simply disclose that he has an interest. They just can't serve. Clause 14 gives the Commission the responsibility of regulating and controlling the operation of gambling in Trinidad and Tobago. Under 14.2, the Commission has an expansive list of duties, including making recommendations to the Minister relating to the industry, equipment or devices associated with gambling, gambling establishments, licensing activities, collection of fees and levies, and resolution of disputes. Clause 17 mandates the Commission to give effect to the policy directions of the Minister as it relates to the regulation of gambling. Clause 19 sets out the funds of the Commission. Clause 20 indicates what expenditure will be allowed by the Commission. Clause 21 gives the Commission the power to maintain a bank account. It is important to note that given that the state may appropriate sums to the Commission, in other words, we may give the Commission a subvention as set out in Clause 19A of the bill, Clause 21.4 provides for surplus funds that the Commission may have to be remitted to the consolidated fund at the end of the year. Clause 22 requires the Commission to furnish the Minister of Finance with a budget and other important information as required. The accounts of the Commission will be public accounts of Trinidad and Tobago in accordance with the Constitution. The Exchequer and Audit Act will apply to audits of the annual accounts. Under Clause 24, the Commission must transmit to the Minister of Finance a report that addresses the activities of the Commission during the preceding year. These will be laid in Parliament, together with the statements of accounts and the Auditor General's report. The cumulative effect of all of this is that the Commission will be called to account and Parliament will have the opportunity to ensure the Commission is staying within the boundaries of the law. Clause 27 will allow for borrowing by the Commission with the approval of the Minister. Clause 30 prohibits any person from participating in any aspect of the gaming and betting sectors unless they have first acquired a necessary license from the Commission. Clause 31 gives the Commission the power to issue licenses and prescribes the various categories. When one looks at the sheer volume of the various licenses that must be obtained in order to participate in the sector, together with the application of fit and proper criteria in issuing licenses, it is clear that if and when this legislation is passed, that the gaming and betting industry will now be regulated properly for the first time. Through these mechanisms, the Commission will have a significant amount of control at an early stage and will be able to cast a very wide net in respect of the persons over whom it will have oversight. Clause 32 speaks to the persons who may apply for license and prescribes a procedure. Clause 32(4) stipulates that notice of any application must be published in the newspapers to allow for public comment and to allow for objections by specified persons. The rationale is that while the industry is one which has the potential of positively contributing to the nation's economy, there may be legitimate concerns about allowing casinos and other gambling establishments into certain residential areas. Clause 33 allows the Commission to conduct investigation of an applicant for a license and their associates. Clause 36 stipulates the form of license. Clause 37 itemizes the conditions of the license. Clause 44 of the bill details the machinery for the Commission to be able to continually review licenses. This review is necessary where there is reason to suspect activities may be carried out in a gambling establishment in breach of a license. As a necessary part of this machinery, provisions have been included to ensure that the requirements of natural justice are met. That is, before a review is undertaken by the Commission, it is obligated to notify the licensee and inform him of the procedure of the review, give the licensee and other parties the opportunity to be heard in the review process. And they must also notify the licensee of their decisions, actions to be taken, and reasons for the decision. Clause 45 and 46 speak to suspension following a review and revocation. Clause 47 seeks to place an obligation on licensees to notify the Commission of any change in their circumstances. This is very important. The appeals process is addressed by Clause 50 of the bill. Parts 4 and 5 of the bill, from clauses 53 to 62, deal with gaming shops, betting shops, premises where gaming and betting activities are carried out, and how to navigate the transitional phase when the Act comes into operation. Clause 53 provides that all persons who own and operate gaming machines or betting shops, subject to the provisions of the Liquor License Act and the Registration of Clubs Act, must notify the Commission of their existence and provide certain particulars. If they do not, this shall be reported to the police, and they are required to apply for a license. The reason for notifying the Commission is to allow the Commission to establish an accurate record of establishments which are in operation for effective regulation of the industry. The Commission is also authorized to designate the machines utilized and to approve the games to be played within gaming establishments. Clause 58 provides that copies of the rules of all gambling games shall be available to patrons on the premises, and also the minimum and maximum wagers for each game must be posted in a prominent location. This is to foster public confidence. Part 6 of the bill, clauses 66 to 69, deal primarily with the payment of taxes by entities carrying on gaming and betting. The taxes now proposed are in keeping with those currently being paid under the Registration of Clubs Act, last updated in 2017 and 2018. Madam Speaker, there's an understandable perception that gambling may result in a number of social problems. With this in mind, the bill seeks to establish the Rehabilitation Fund and Development Fund, both of which are intended to ensure that the economic output of gambling will be directed in a purposeful and socially beneficial manner. The Rehabilitation Fund will financially assist NGOs and other groups with treating persons affected by gambling, addiction, and other problems. The Development Fund will be used to assist in areas such as sport, health, social and community work, arts, and culture. The Commission must deposit 2.5% and 5% to the Rehabilitation Fund and Development Fund, respectively, of their revenue. Clause 65 establishes these funds, the Rehabilitation and Development Funds. I now go to enforcement. Madam Speaker, it is appreciated that meaningful change can only be achieved if there is effective enforcement of the laws of Trinidad and Tobago. In this regard, the bill addresses enforcement under Part 7 and deals with the powers of authorized officers, who will be a person appointed by the Commission, a member of the police service, constable appointed under the Supplemental Police Service Act, and a member of the Municipal Police Service, any other person duly authorized by the Commission. This allows the Commission to carry out enforcement activities in a robust and efficient manner. These officers will be given powers in respect of licensed premises, including the power of inspection of premises, the power to examine all machines and equipment utilized in operations, and the power to request copies of any and all documents, records, and the collection of funds, etc. And also to look at complaints emanating from customers and clients. They can also conduct detailed and complex criminal, regulatory, administrative, and background investigations, as well as gather intelligence in relation to organized crime and other activities related to gambling. The need for enforcement is not really simply limited to the police, and as such, authorized officers may require assistance of other bodies, including the Financial Intelligence Unit, Financial Investigations Bureau, the Board of Inland Revenue, Customs Division, and so on. There will be an integrated approach. We believe these powers will be successful in effectively supervising casinos to prevent fraud, money laundering, loan sharking, other criminal activities, and unscrupulous operations where revenue may be underreported. Offenses and penalties. Part 8 of the bill, clauses 70 to 83, deals primarily with gambling and betting offenses, and offenses involving minors, general offenses, and the related penalties. Part 8 is divided into 3 divisions: gaming and betting offenses, minors, general offenses. Some of the offenses will be using premises for license activity without a license, carrying out license activity without a license, manufacturing, supplying, installing, or adapting gambling software, cheating. This has been amended so it no longer only deals with cheating by various people, but also any person who cheats will be guilty of an offense, thereby fostering public confidence in the gambling sector. And another offense, engaging activities that invite or enable persons in a prohibited territory to participate in remote gambling. Madam Speaker, the offenses and penalties, and this would include matters such as bringing a firearm on licensed premises without permission or without an owner's license, and also a new offense where persons will willfully interfere with an investigation by influencing, threatening, harming, or impeding a potential witness, furnishing false information, otherwise impeding an investigation. We believe that these offenses and penalties in Part 8 will ensure that casino gambling is fair, honest, and free from criminal influence and exploitation. There are also provisions for administrative penalties if criminal thresholds have not been reached, and the Commission will be empowered to pursue sanctions in the form of administrative fines. And this is not a unique situation. Madam Speaker, I want to reinforce that where the Commission seeks to enforce its powers, the Commission is required to, again, adhere to the principles of natural justice by notifying the person of the penalty to be imposed, the reasons thereof, of making its decision, and they must do so within 1 week. This will preserve the rights of business owners. The last part of the bill, or the penultimate part of the bill, clauses 89 to 90, deals with the minister's power to make regulations, and part 11, schedules 1 to 6, address the staff of the commission, fit and proper criteria, internal controls, accounting systems, data requirements, taxes payable, and other consequential amendments. How much more time do I have, Madam Speaker?
56:45.
All right, so I have 16 minutes. Okay, very good. Now, Madam Speaker, I just want to make a point. We in this Parliament have gone beyond the normal requirements in interrogating this bill. We have consulted ad infinitum. We have answered every single question. But throughout the 3 to 4 years, Madam Speaker, the proceedings of this Joint Select Committee have been dragged out and delayed. We have bent over backwards to facilitate questions coming from the opposition, questions coming from the industry, questions coming from stakeholders. We have brought in experts because none of us, at least as far as I know, no members of this House and the other place are experts in gambling. I'm not aware of that. So we brought in world-renowned international experts to advise us not just on the law, but on the efficacy of the provisions that were being proposed, and also to recommend enhancements and improvements to the bill. I want to stress that the familiar complaint was laid to us that where are the regulations? And we produced draft regulations 3 years ago in March 2017. And these regulations have been interrogated ad infinitum, not just by stakeholders, not just by members of the committees, but by our international experts in video conferencing with the committee. I don't think there's any Joint Select Committee that has done this amount of work on a piece of legislation other than the Insurance Committee that I have been associated with. There may be others, but procurement, yes. There may be others, but this is one of the most comprehensive, detailed examinations of a piece of legislation that is overdue for more than 20 years. Overdue for more than 20 years. I just want to make it clear that in the committee, we have gone to extraordinary lengths to allow participation of all members of the industry, everybody concerned, participation of all members. I want to make it absolutely clear. I intend to re-emphasize that not only have we dealt with the bill, we have dealt with the regulations. I therefore, Madam Speaker, cannot contemplate a situation after this Parliament has gone through this for 4 years, and that this bill is the exact same bill laid by members opposite. The bill that was laid in 2016 was identical, and we benefited from the observations and input of honorable members of the opposition. Many of the amendments to the bill were made based on requests coming from members of the opposition. And therefore, I could see no reason whatsoever, Madam Speaker, unless there is some motive for members opposite not supporting this long overdue reform of the gambling sector. And therefore, I expect we will get unanimous support of members opposite. I beg to move.
Honourable members, I will now propose the question for debate. Be it resolved that this House adopt the report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016. Member for Cuba South.
Thank you, Madam Speaker, as I join this debate on the motion to adopt the Gambling, Gaming and Control Betting Bill of 2016. Madam Speaker, after having listened to the member for Diego Martin Northeast and the Minister of Finance, I thought I was in a fish market, based on his attempt to bully and the tactics, the strategy that he attempted to foist upon us here this evening as it relates to this particular motion, which is before the House. And, Madam Speaker, the Minister attempted to create a narrative and paint a picture that members of the opposition on the Joint Select Committee dragged out or dragged on the deliberations of the committee. The Minister, by his own admission, indicated that no one on the committee was an expert in gambling, had hands-on experience in gambling, and that is why the committee had to seek international advice. And that is why there were 15 firms or 15 experts that applied to be part and parcel of the engagement process. The committee had to vet properly the applications that came before the committee, and in addition to that, to ensure that there was no conflict of interest and so on before the committee. So to say that members of the opposition dragged on the work of the committee is disingenuous on the part of the Minister of Finance, Madam Speaker. And I will deal with the issue of regulations and whether the draft regulations was updated and so on, and whether there was meaningful consultation with the stakeholders as it relates to this particular issue. Meaningful consultation, Madam Speaker, as it relates to the report of governance and associates, Madam Speaker. But more important, Madam Speaker, I want to place this industry, or the importance of this industry, in a socio-economic context too, Madam Speaker. It has been established that this industry employs approximately 20,000 persons. 75% of those employed are women, single mothers, and the average dependence of this 20,000 households, approximately 5 persons, Madam Speaker. And I simply want to read from Ms. Ayana Francis to further amplify the socio-economic importance of the industry, of Mentor Ali Laventil, who was a reception supervisor at Mapao Club. Her job is to greet clients as they enter the club. The starting salary, she said, compelled her to join the gambling industry, and I quote, "I am from Laventil, what people call a high-risk area. I'm a single parent. My daughter's dad was shot and killed 4 years ago. With my job, I have been able to take care of my daughter and help my mom. I have been afforded a lot of concession at my job to help my family live a much more comfortable life and have a better standard of living." End of quote. And she indicated further that many single parents like herself and people who have just left school have been able to get jobs within the industry and so on, Madam Speaker. And Madam Speaker, immediately I want to go into the bill that forms part and parcel of this report and the motion that is before the House, Madam Speaker. Because, Madam Speaker, I have established the socio-economic importance of the industry. I've also pointed in the direction of the employment and importance of employment to persons in Trinidad and Tobago, and more importantly, single mothers. And I want to focus on the bill itself and make some observations on behalf of the opposition as it relates to vagueness and uncertainty and the need for further clarity and clarification, Madam Speaker. Madam Speaker, as it relates to my observations and that of the opposition, Madam Speaker, I want to point this House to part 1 of the bill as it relates to the preliminary part and immediately go to part 1(4) of this bill as it relates to what is an associate. And the bill states an associate in relation to a licensed business means any person who holds any financial interest or can exercise any power, control, or influence over the licensed business, Madam Speaker. And Madam Speaker, it is important to note that what is the standard, given the wide latitude of what an associate is defined as, this is especially open to abuse, taking into context that the provision does not go on to describe what power administrative and criminal law, Madam Speaker. There's an overarching principle, that a person must be certain of the parameters of what we call permissible conduct, and a situation where those critical terms remain uncertain, unclear, and undefined, the power lies for interpretation with the Commission, Madam Speaker. And Madam Speaker, in cases of a perverse interpretation, the aggrieved party then has to go to the court to vindicate themselves. And in going to the court, this entails delay, time, expense, and inconvenience, Madam Speaker. And in addition to this, Madam Speaker, as it relates to the vagueness or the need for further clarity and so on, I will move on to the interpretation. And in the bill, it speaks to an authorized officer. An authorized officer means a person appointed by the Commission to carry out the functions of an inspector pursuant to Section 71. B, a member of the police service. C, a constable appointed under the Supplemental Police Act. D, a member of the municipal police service appointed under the Municipal Corporation, Madam Speaker, and any other person duly authorized by the Commission, Madam Speaker. And Madam Speaker, the issue of an authorized officer, the Commission will have the power to appoint to act on its behalf and carry out the functions that are required, Madam Speaker. And the question arises whether or not, Madam Speaker, that police officers who will be required to carry out the role and functions or the responsibilities of the Commission, who will they be accountable to? Will they be accountable to the Commission? Will they be accountable to the Commissioner of Police? And so on, Madam Speaker. And the duality in the reporting requirements of these officers will create inevitable confusion and, as I said, conflict of interest, Madam Speaker. And this is why there is the need for further clarification and amplification. And, Madam Speaker, I ask the question, will there be a special unit within the police service of Trinidad and Tobago that will be created specifically, because the minister has admitted this is a very complex, a very intricate industry. There needs to be specialized training and so on to carry out the role and function of the Commission. And I do not know who within the police service has the expertise at the moment in relation to carrying out enforcement, Madam Speaker. And that is why I asked whether there will be the need for a special unit and how we will go about training the police officers, Madam Speaker. And this leads me to the very issue, too, of a member of the police service appointed on a municipal police, appointed under the Municipal Corporation Act, Madam Speaker. Madam Speaker, we have heard in this very said House, budget after budget presentation from the Minister of Finance that there will be the appointment of 100 municipal police officers in the 14 respective regional corporations throughout Trinidad and Tobago. And Madam Speaker, I've done a bit of research, and currently at the Chaguanas Borough Corporation, there's 31 municipal police officers. At the Princeton Regional Corporation, there's 30 municipal police officers. At the Kuva Tabaki Talpari Regional Corporation, there's 22 municipal police officers. Again, we must take note of the fact that they have promised in the last 5 years to fill 100 municipal police officers. How much of this existing establishment or complement at the moment from these respective regional corporations will be utilized to carry out the role and function of the Commission? And in addition to that, Madam Speaker, the question begs itself, where will the training, where will the expertise in terms of officers within the local constabulary units come from within the framework of what is being articulated here this afternoon by the Minister of Finance on behalf of the government of Trinidad and Tobago, Madam Speaker. So, again, they have taken 5 years on this particular piece of legislation. They have failed to create or to fill the 100 vacancies within the local constabulary units and so on. So I do not expect this to become a reality given the lazy approach, the lackadaisical approach, the incompetent approach of this government over the last 4.5 years, Madam Speaker. Madam Speaker, I will move on to deal with the very issue of what the report and what the bill seeks to focus on, which is the establishment of a gaming, or what we would call a Gambling, Gaming and Betting Control Commission, Madam Speaker. And Madam Speaker, in Part 2 of the bill, Clause 6.2, the Commission, it states very clearly that the Commission shall be managed by a board appointed by the President on the advice of the Minister for the purpose of exercising such powers and duties as are conferred upon it by this Act, regulations made hereunder, and any other written law, Madam Speaker. Madam Speaker, given the constitutional framework of Trinidad and Tobago, the President has absolutely no discretion in the appointment based on the fact that the sole power really lies in the hands of the Minister of Finance and the Cabinet of Trinidad and Tobago, Madam Speaker. So the appointment process really lacks what we would call independence, and it is a purely political process subject to a minister, as I said, via the Cabinet of Trinidad and Tobago. Madam Speaker, we in the opposition, we would have preferred, Madam Speaker, the President appointing the commissioners of this Control Commission after consultation between the Prime Minister and the Leader of the Opposition. And just as in Clause 6.3, where it states that the board shall consist of a chairman and not less than 5, no more than 9 other members, one of whom shall be appointed on the recommendation of the Chief Secretary of the Tobago House of Assembly in accordance with subsection 5. We would have loved to see also a person represented by a body representative of the gaming industry of Trinidad and Tobago, Madam Speaker. Madam Speaker, and we are making these observations based on, in recent times, what we have seen unraveling itself within the operations of the National Lotteries Control Board, Madam Speaker. Because at the end of the day, a minister carrying out total control under the current framework, it can lead to what we would call manipulation of the political process, and certainly does not lend itself to an independent process, what we are supposed to seek to achieve, Madam Speaker. Madam Speaker, I will also go on to focus on the term operated, Madam Speaker, because Clause 6, if you read it, Clause 6 states, a person, and this is a new clause because the minister went on to make a song, dance, and fury about this being the identical bill which was laid by the partnership government in 2015. And I'll come to the issue of penalties and offenses and so on when I reach that juncture, to show that it is not the identical bill, or what he would term comma and full stop, and the gallery that he attempted to engage in here this evening, Madam Speaker. Madam Speaker, the public make them out long time enough, Faizabad. So they could dance, they could open what, they could do what. Their time is limited in the Parliament of Trinidad and Tobago. And Madam Speaker, I'm sure they will crash out of the government whenever the member for Diego Martin Ortiz calls the date for the general election, Madam Speaker. Diego Martin West, sorry. Well, we know you are the chairman of the party. We know you are the chairman of the party, Madam Speaker. I know the member for Diego Martin Ortiz is smiling at what I'm saying. Whether who is the de facto prime minister or not, I will not go there. Madam Speaker, but more importantly, Madam Speaker, 6A states that a person who has operated a gambling establishment prior to coming into the force of this act, B, holds a license under this act, intends to apply for a license pursuant to the provisions of this act, has a financial interest in, but does not operate a gambling establishment, Madam Speaker, shall not become eligible for appointment to the board, and in the case of persons who hold positions on board, an application for a license under this act shall be grounds for automatic termination of the member's appointment on the board, Madam Speaker. Madam Speaker, the term operated is not defined in this act, and as a result, it is unclear and uncertain. And Madam Speaker, the question begs itself, or the question follows, whether it applies to persons who are owners or does not apply to managers and other key personnel, Madam Speaker. Any interpretation of this word must take into consideration of the fact that by virtue of the different provisions of this bill and to satisfy the fit and proper criteria, Clause 6 purports to exclude, as I said, a class of persons from being eligible for appointment to the Commission Madam Speaker. Madam Speaker, it seeks to deter any person who has operated a gambling establishment prior to the commencement of the Act, Madam Speaker. Madam Speaker, I will go on to the powers and duties of the Commission. And under Clause 14, subsection 2, and it reads very clearly, Madam Speaker, without prejudice to the generality of the foregoing Commission, the Commission, shall A, grant licenses pursuant to the provision of this Act and regulations made hereunder. B, impose conditions in the granting of licenses subject to the provisions of this Act and regulations made hereunder. And Madam Speaker, this is where the Minister of Finance attempted to place the onus or the responsibility on the opposition as if we did not understand our role and function in the Joint Select Committee, Madam Speaker. Madam Speaker, and the importance of regulations was underscored by one senator, the member for San Fernando West, when in 2015, on the 9th of June 2015, he spoke in another place, Madam Speaker. And Madam Speaker, I want to quote from the Hansard of June 2015, Madam Speaker, and probably refresh the memory of the Attorney General, Madam Speaker. And he indicated in his contribution at that point in time, Madam Speaker, of the need for serious consultation and also for the importance of the regulations, Madam Speaker, when he spoke in the House, in the other place, and indicated that this serious government that has been involved in a serious consultation that treats workers' rights seriously, says to the people of Trinidad and Tobago, other than by way of Senator Hardy's general cross-talk, other than by way of his grumblings and mutterings on the floorway, other than by that way, this serious government says to the people of Trinidad and Tobago, take us seriously because we have had no consultation with the stakeholders, Madam Speaker. And he went on to indicate about the bill needing a three-fifths majority, and as I said, the importance of the regulations. And I quote, Attorney General, has the Honorable Minister, in considering the architecture, the Attorney General likes to use two terminologies in this House, architecture and proportionality in his contribution, Madam Speaker. He said, has the Honorable Minister, in considering the architecture of this bill and prescribing regulation, factored that this bill does not allow for an offense to be attributed to the regulation, the Minister may make regulations prescribing anything necessary or convenient for carrying out or giving effect to the Act, Madam Speaker. And more importantly, in relation to the operationalizing of this bill, the regulations are of critical and paramount importance. And when the Minister spoke during his contribution, he said that the regulations have been out there and so on. And we have had sight of the regulations. But it is important to note, Madam Speaker, that there is a report to the Parliament of Trinidad and Tobago Joint Select Committee on Gambling Control Bill 2016 on the regulations to be made under this bill. And this report has been prepared by the firm Governance Associates Limited, which was engaged by on behalf of the Joint Select Committee through the Parliament of Trinidad and Tobago. And today, and we want to applaud the work and the advice of the firm Governance Associates Limited as it relates to what they did for the benefit of the Joint Select Committee and by extension the gambling industry and by extension Trinidad and Tobago, Madam Speaker. So it is important that the opposition places on record its deepest sense of appreciation to the good work done by Governance and Associates, Madam Speaker. Governance Associates Limited, Madam Speaker. And I want to quote very clearly that it is important that they said, and I quote, having considered the drafts, we offer the overarching commitments, Madam Speaker. They provide a workable foundation for the new regulatory scheme. We would recommend that the settled, I want to reiterate, not the draft, we would recommend that the settled regulation be the subject of consultation with the industry to ensure that there are no unexpected issues. And I ask today, I challenge the Minister of Finance to tell this House and tell the stakeholders whether there has been meaningful consultation and feedback from the stakeholders on the settled, I want to reiterate, on the settled regulations. And if the minister was a very proactive, I could remember when I was the minister in the Ministry of Finance to Minister Hawaii. The current Minister of Finance used to come to the Parliament of Trinidad and Tobago and refer to my then senior minister as Lazy Larry. And he attempted to paint the then Minister of Finance as not knowing what he was doing at that time. And I could remember last week when he was contributing, he referred to quack doctors and engineers and so on in Trinidad and Tobago. I do not know if he could point towards a direction of a stadium in Grenada and a wall somewhere in Maraval, Madam Speaker. Madam Speaker, and we must ask the question, why after into their final months as the outgoing government of Trinidad and Tobago, why there is no settled regulations so that there can be feedback. He boasted about it. He called out a list of stakeholders when he spoke about consultation and getting feedback and so on. And I want to ask him today, Madam Speaker, has there been any feedback from, for example, the Trinidad and Tobago Members Club as it relates to the settled regulations? Whether there has been any feedback from the Union of Members Clubs and Lottery Workers, Madam Speaker. Whether there has been any feedback from Mapao Club, and I could go on and on as it relates to, and whether there has been any feedback from the Financial Intelligence Unit, the Board of Inland Revenue, the Integrity Commission of Trinidad and Tobago, the Commissioner of Police, Customs and Excise, the Betting Levy Board, and so on. All very important institutions in Trinidad and Tobago as it relates to the operationalization of the bill. Madam Speaker, and that is why I have to underscore the point here, Madam Speaker.
Member for Cubasau, your initial speaking time is now spent. You're entitled to 15 more minutes to wind up your presentation.
Thank you.
Please proceed.
Thank you, Madam Speaker. And that is why I have to debunk this misleading narrative which was created by the Minister of Finance that there has been meaningful consultation with the stakeholders of Trinidad and Tobago, Madam Speaker. Madam Speaker, that was a term of the past because that was a term that he used 32 times in his first budget presentation, and that has gone through the window, Madam Speaker. Madam Speaker, Madam Speaker, I want to go on to the very important issue too, as it relates to the Commission and the importance of, again, we are very concerned about a politically appointed board, appointing a chief executive officer, appointing a person who we believe will be subject to doing the bidding of the political directorate in this heavily charged political environment, Madam Speaker. And in that regard, we are very concerned as an opposition as it relates to, under this part of the bill, Madam Speaker, the draft bill, we are concerned about clause 17, where it speaks of the Commission shall give effect to such written policy directions of the Minister in relation to any matter concerning the regulation of gambling as it appears to the Minister to be in the public interest, Madam Speaker. This gives the Minister wider and what we would call autonomous powers, and the issue of political interference can certainly arise, Madam Speaker, given the track record of this government and how many cases have gone to the courts of Trinidad and Tobago. And it is clear, based on the interpretation of the courts of Trinidad and Tobago, that the government continues to infringe on the free and what we would call fair democratic process of the citizenry of Trinidad and Tobago, Madam Speaker. Madam Speaker, this leads me to the very important issue of the licensing regime, Madam Speaker. The license given, and when you look at Part 3, the licensing regime of this particular bill, and it focuses on the Part 3, Clause 31, Madam Speaker. The Commission shall issue licenses in accordance with the provisions of this Act, and it spells out a gaming operator's license, a gaming owner's license, a bookmaker's license, and promoter's license, a gaming machine operating license, a gaming machine distributor license, a technical operator's license, a premises license, a personal license, a gaming machine manufacturer license, and any other license as the Commission may stipulate from time to time as it deems necessary and related to the discharge of its duties and functions, Madam Speaker. Madam Speaker, this is a government that continues to boast about they are championing the ease of doing business in Trinidad and Tobago. Given this regimented, what we would call licensing regime that will be required to operate in the gaming and betting sector, not only the gaming and betting sector, Madam Speaker, it also, this will focus on, in the 41 constituencies of this country, there are many watering holes in this country, and in those watering holes, there are slot machines, amusement, roulette machines, and so on. Madam Speaker, whether it is from Charlottesville to Palatuvia to Basta Hall, Bocaro, down in Point Caranage, and so on, Madam Speaker. Given the rigid fit and proper criteria, it can lead to massive job losses because out of the frustration, out of the regimented criteria and so on, Madam Speaker, bar owners may decide that they will not be part and parcel of this. There is too much of bureaucracy, there is too much of additional costs, the profit margins and so on, and it may lead them in the direction of closing down. It may lead to the death knell of a number of these watering holes and so on in Trinidad and Tobago. And under this government, 63,633 people have lost their jobs in the formal and informal sector, and going in this direction could lead to further unemployment, further job losses in Trinidad and Tobago, Madam Speaker. And as I said, so from where they seem to have what we would call a conflict in terms of their policy thinking and execution, they boast about, as I said, creating that enabling environment in the ease of doing business. But in recent times, I think we have dropped on the global index, and based on the overall operations of this government, it is a line-up government, because you have to line up for gas, you have to line up for birth certificates, you have to line up for passports, you name it, Madam Speaker. In fact, we are now, we have now gone on record in the Caribbean. We have the longest waiting list to get a passport now, and I think it is about between 3 to 5 months to get your passport. And that is the track record of a government that says it cares about the people, and it is creating the enabling environment to do business in Trinidad and Tobago, Madam Speaker. Madam Speaker, we on this side we are very concerned about the chaos, the confusion that this government continues to create in the lives of the ordinary citizens of Trinidad and Tobago, Madam Speaker. And Madam Speaker, I want to come to the very important point about Part 8 of the bill, which focuses on offenses and penalties and so on. And Madam Speaker, here is where the Minister of Finance is clearly caught, as we would say, using the cricketing analogy, caught in the slips, because Madam Speaker, you said that this was the exact bill, Madam Speaker, and even went to underscore that it was the exact bill because he didn't change what? He didn't change a full stop, he didn't change a comma, and so on. But Madam Speaker, how come there's increased penalties? How come there's increased penalties, Madam Speaker? And you know, the increased penalties and a pet subject of the member for San Fernando West, the Attorney General, disproportionate, and whether the offenses and penalties go in proportionality. I see my colleague, the member for Port West, is smiling broadly as it relates to that, because when the Attorney General was in another place, and I want to quote from the Hansard of the 9th of the 6th, 2015, Madam Speaker. He spoke of excessive criminalization, Madam Speaker, and the work. It is fitting, Madam Speaker, that the offenses prescribed in this legislation includes. It is fitting that the offenses prescribed in this legislation includes offenses on the summary conviction of up to $5 million. Madam Speaker, it is fitting that an argument against excessive criminalization can be levied against this bill. And it is not true that the Honorable Minister of Finance and Economy knows the effect of excessive criminalization, Madam Speaker. The honest minister certainly participated in some excellent work, which we as a Senate was privileged to do in the Joint Select Committee, and he went on to speak about the penalties and so on, Madam Speaker. And yes, I know what I'm reading from, Madam Speaker. Attorney General, you must not be hypocritical, Mr. Attorney General. And you must tell this House what has changed your position today based on what I will continue to read, Madam Speaker, on the issue of excessive criminalization and whether you are in agreement, Attorney General, with the increased penalties which are in the draft bill, Madam Speaker. And did you give your colleague, the Minister of Finance, the advice, the legal advice, as it relates to your role in the Cabinet of Trinidad and Tobago, Madam Speaker? And as I said, for example, increased penalty, subclause, and this is as it relates to clause 70, increased penalty, subclause 2 states that the penalty for the contravention of subclause 1 is $250,000, and now to imprisonment to 20 years, as opposed to 1 year it was 1 year in the original bill. It is 20 years now. Yes. Our bill, it was 1 year, and that is the deception of the Minister of Finance, and that is why you cannot trust the PNM. That is why the citizens cannot believe them, because they speak with forked tongues consistently, Madam Speaker. Forked tongues consistently, Madam Speaker. And also as it relates to clause 21, Madam Speaker, the increased penalty, subclause 2, offenders will now be liable on summary conviction to a fine of $250,000. And again, the penalty in terms of imprisonment to 20 years. We had proposed 6 months in our original bill, and it has moved from 6 months to 20 years. And the Senator Faris Al-Rawi had the goal to speak about excessive criminalization in 2015. So, Madam Speaker, the writing is on the wall. The writing is on the wall that this is a mamagai government, this is a deceptive government. You cannot trust them with anything that they bring in the Parliament of Trinidad and Tobago, Madam. And, Madam Speaker, I am sure the public of Trinidad and Tobago, the voting public, will not gamble with them for another 5 years. Will not gamble with them for another 5 years, Madam Speaker. Madam Speaker, if we are to really examine the modus operandi of the PNM for the last 5 years, they have been a government. Well, they have given away the country already, Shagun Aziz. There's no hope. This is a tip. This report and this bill is a typical PNM bill, taxing you, threatening to jail you, Madam Speaker, and taking your property and assets away, Madam Speaker. That has been the focus of this government for the last 5 years, because they cannot deliver. They have been incompetent. They continue to blame Kamala and the opposition for their failings, for their missteps, for their lack of delivery. And that is why I am saying that we on this side, we reject this Joint Select Committee report. We will not be part and parcel of the mamagai and deception of the People's National Movement led by Dr. Keith Rowley. Madam Speaker, I thank you.
Member for St. Fernando West.
Thank you, Madam Speaker. Madam Speaker. Madam Speaker, it gives me great pleasure to enter this debate. It also gives me extreme pleasure to answer my good friend, my colleague, member for Couva South. Because, Madam Speaker, there's an old saying about sound coming best from certain types of vessels. And what I can say, Madam Speaker, without a shred of doubt, is that I intend to decimate the argument put forward by the member for Couva South. Madam Speaker, all of that tirade and noise and drama effectively results in the honorable member talking to barely a few points. The honorable member effectively made a song and a dance about regulations. The honorable member made a song and dance about ministerial overreach, meaning that the minister could somehow control the authorized officers. The honorable minister of finance was met with another concern, job losses coming from the member for Couva South, and the last one was the increased penalties. 4 points is effectively what they made. Now, Madam Speaker, what I find astounding about the honorable members is that the entire argument made by Couva South seemed to come from a contribution which I gave in June 2015. And Madam Speaker, let me for the record start to correct what we heard come from the mouth of the honorable member opposite. The Minister of Finance said in English, Madam Speaker, which is the language of this country officially in this parliament, that the bill that was laid in this parliament by this government was word for word the bill that came to the parliament in May 2015 by the last government. The member then went on to report upon the Joint Select Committee's work, and in that Joint Select Committee's work, Madam Speaker, in highlighted text, in submissions coming for amendments, right here, paid for by the taxpayers of Trinidad and Tobago, and given to members opposite, are all of the amendments to that bill. So, Madam Speaker, it is childish and nonsensical for the honourable member to pretend that the Minister of Finance said that the motion to adopt the amendments from the Joint Select Committee is the same thing as the bill that was laid in 2015, now 2016, puerile. Madam Speaker. It is puerile. But, Madam Speaker, worse than that, the honourable member said that he took pleasure as a government minister in the Ministry of Finance. This is not a newcomer member to the Parliament, Madam Speaker. For the member to not know that we are debating a motion to adopt amendments from a Joint Select Committee that took 4 years to get done, Madam Speaker, it is, Madam Speaker, I want back the money for the people of Trinidad and Tobago, paid to that honourable member to keep him in the Parliament to make a submission like that, Madam Speaker. On behalf of the taxpayers of this country, we demand a refund. Madam Speaker, Madam Speaker, you know, Madam Speaker, I sat quietly during the contribution from the honourable member, you know. So, Madam Speaker, let's get to this. Let me put this into context for the listening, sensible public through you. Madam Speaker, we are here debating a motion to adopt the work of a Joint Select Committee. That motion is premised upon a report coming from a Joint Select Committee. That report, Madam Speaker, is under the hand of the chairman, the Minister of Finance. That report was laid last year, Madam Speaker. In that entire report, we have evidence of the adoption of the Joint Select Committee's work in 2016, 2017, 2018, 2019. 4 Joint Select Committee years where we adopt the work and we bring it forward. In those 4 years of work, the members of the opposition participated in the Joint Select Committee. A report was sent to the honourable members to sign in November last year. We are now in February of 2020. November, December, January, February. The members said they needed superior's consent to sign the report and that they required a mere 2 weeks to get that consent. The Minister of Finance then said, well, okay, you want 2 weeks, take a month. 4 months later, we come to this Parliament today. The Joint Select Committee is laid. Madam Speaker, you know what is not in the Joint Select Committee report? There is no minority report.
Make it up.
There is no minority report coming from the members opposite, and the member has the temerity to say that this government is lazy, this government is slothful. Madam Speaker, the evidence of sloth and laziness is to take a 2-week request to get permission from Siparia to sign the report, and 4 months later, the bound report, Madam Speaker, I have not heard a standing order, so I'm not giving way. Madam Speaker, the bound report.
When your leader decides to recognize me, then we back to the room. You know, I believe I first heard that coming from this side. I first heard that in this very debate coming from your speaker. But I remind all speakers, even if it is said outside, when you say it in here, it is your own act, you have adopted it. Okay? We call each other either by our portfolios or the honorable member. We are all honorable in this house. Continue, Attorney General.
Madam Speaker, the Joint Select Committee's report, coming 4 months after a request was made for the member for Siparia to give consent to the report, 4 months later, we stand here in this House with no minority report. Not a single shred of evidence to talk to the 4 points made. Regulations, ministerial overreach, offenses being supposedly excessive, Madam Speaker, or the impact upon the job losses. So, Madam Speaker, my friends opposite want to come today and talk about hard work. Madam Speaker, let me get on to the points made by the honorable members in the context of the bill. Let's start with the regulations. The first big point made by the member opposite. Madam Speaker, I want to read, Madam Speaker, from a cabinet note coming from the member for Siparia's government. The first cabinet note, Madam Speaker, is that considered on the 6th of June 2013, confirmed the 13th of June 2013. And that effectively asks for establishment of a legal and regulatory framework for the gambling and gaming industry in Trinidad and Tobago. They set up a working group, Madam Speaker, and in that, the government then went to work in 2013. In 2015, there's a cabinet note, and here's the minute. The cabinet note was considered March 26th, 2015. The decision was on April 2nd, 2015. And listen to what that cabinet minute says. Cabinet agreed to approve the under-mentioned documents regarding the legal and regulatory framework for the gaming industry, copies of which were attached to the note. Number one, the Gambling, Gaming and Betting Control Bill 2015. Number two, the Gambling, Gaming and Betting Control Application for Gaming Licenses Regulations 2015. Number three, the Gambling, Gaming and Betting Control Accounting and Internal Control Regulations 2015. Number four, the Gambling, Gaming and Betting Control Anti-Money Laundering Casino Regulations 2015. Number five, the Gambling, Gaming and Betting Control Gaming Devices and Equipment Regulations 2015. And number six, the Gambling, Gaming and Betting Control Betting Regulations 2015. What does that mean? The members opposite had the copy of the regulations since 2015, Madam Speaker. Those regulations came into the Joint Select Committee's work. In the Joint Select Committee's work, we referred them to the expert to the committee, and this is Governance Associates. And Madam Speaker, the honorable member for Couva South comes here today to say, point number one, do not bring this bill into effect because the regulations need holistic and comprehensive consultation. And then the member purports to rely upon the wording in the report, So, Madam Speaker, let me read what the honourable member did not have the courage to read, coming from the report of Gaming Associates. It's a report to the Parliament of Trinidad and Tobago Joint Select Committee on Gambling, Gaming and Betting Control Bill 2016 on the regulations to be made under the bill. And Madam Speaker, let me skip right to the relevant part. After the honourable experts to the committee reported on the regulations, and they said in respect of the regulations, number one, they provide a workable foundation. Number two, the Commission should be given greater flexibility over the commencement of new functions. Number three, that the regulations appear to be continuations of current rules. We support their carrying forward without amendment. But Madam Speaker, here's what they say, and this is material. We suggest the new Gambling Commission, let me repeat that. We suggest the new Gambling Commission must be permitted sufficient time to gain that knowledge and understanding to enable it to take informed action when it moves to introduce more contemporary regulations in any particular area. Let me explain to you why I just stressed what I did. Madam Speaker, if the honourable members had the courage to at least read the bill as proposed to be amended, the first point that they would note is that this act in clause 2, parts 1, 2, and 11, and schedule 1 come into operation on the date of assent. The rest of the act by proclamation. Madam Speaker, what is part 1? Preliminary. What is part 2, Madam Speaker? It is the establishment of the Gaming Control Commission. The report from the experts to the Joint Select Committee, not the experts to the PNM, to the Parliament Joint Select Committee says that the Commission should have time to consider regulations. But Madam Speaker, what I'm shocked and ashamed to hear today is the honourable members pretend that the bill cannot be passed without the regulations being done first. Number one, the honourable member asked me to explain my position between 2015 June and today. Madam Speaker, I can tell you, everything that the honourable member read out in his reciting what I said in Parliament in the Senate then, as it related to the need for regulations, Madam Speaker, we have amended the regulation provision to say that the regulations are to be by affirmative resolution. Number two, Madam Speaker, we say that the Commission can be installed first. Number three, Madam Speaker, shamefully on the part of members opposite, Madam Speaker, we passed the public procurement law, Madam Speaker. In passing the procurement law, Madam Speaker, it was specific that the Public Procurement Act would be proclaimed, the Commission would be installed, the public procurement regulator, by the song and dance method to appoint that regulator. But Madam Speaker, as they complain about the regulator and the last president taking a long time to do that, because the government has no control with that, Madam Speaker, here's what Section 63 of the Public Procurement Act says. Section 63 effectively allows the Public Procurement Commission, the regulator, to produce the regulations. So, Madam Speaker, as Siparia chuckles away, trying to hide the position, as Couva South has left the chamber, number one, Madam Speaker, the regulations are to be produced after the procurement of the Act, the proclamation of the Act. Number two, the case in precedent is the Public Procurement Act, Madam Speaker. Number three, who piloted the Public Procurement Act? The UNC. So today, we have to do regulations at the end. Today, we can't pass the gaming law because regulations are not in effect. Madam Speaker, can the babbling coming from Siparia cease? She can't help it. She can't help it.
Okay, so, Member for Siparia, everybody is going to have an opportunity to join the debate if they so wish. Okay, I remind everybody of Standing Order 53 with respect to members who are not speaking. They would listen in silence, no excessive crosstalk, and very low volumes. Remember, people here were talking about how loudly we sound, but the chamber carries a certain amount of reverberation. So please, Attorney General.
Speaker, under the public procurement legislation piloted by the UNC, it's okay to have regulations after. Under this law, it is not okay. So all of a sudden, you must forget the methodology to produce regulations, abandon the approach taken in the public procurement route, and today, with no minority report, Couva South comes to tell us, bill can't pass because regulation's not ready. And I just read to you from the expert to the committee, the Joint Select Committee, which said that the commission, obviously when appointed, Madam Speaker, you can't appoint the commission until you pass the law. You can't pass the law, Madam Speaker, until we pass this chamber today. So, Madam Speaker, inconsistency number one in relation to regulations. You did not read the whole report to the Parliament, Couva South. Inconsistency number two, the public procurement law says openly, by way of precedent, that we can take this approach. Inconsistency number three, Section 63 of the Public Procurement Act allows that. Madam Speaker, and that's in terms of comparative work. Madam Speaker, let's get further down to the position. Madam Speaker, the second point made by the honourable member opposite is the power of the minister. And he was talking, the honourable member, about the appointment of the board, Madam Speaker. The board is the commission. Madam Speaker, for 4 years in the Joint Select Committee, the member for Couva South, the member for Chaguanas West, the other members of the Joint Select Committee had nothing to say about the powers of the minister by way of appointing. There's no minority report. The independent senators have signed this report in support. But today, Madam Speaker, there's a song and a dance about ministerial overreach. And Madam Speaker, here is where that song and dance gets interesting. The honourable member for Couva South made a submission that because the authorized officers, meaning Trinidad and Tobago police officers, municipal police officers, supplemental police officers, SRPs, and authorized officers coming from the Gaming Industry Commission, because those officers are working in tandem with the commission, we get a schoolboy debate today asking us to say, well, who's going to supervise them? They have dual roles of appointment. Who backs them constitutionally? Madam Speaker, again, a most infantile argument. Madam Speaker, this was dealt with by the Privy Council in R.V. Hines, Madam Speaker. In the Hines decision, the backing of the Police Service Commission was set out by everybody being made aware that you answer to the Commissioner of Police if you're a policeman, you answer to the Police Service Commission if you are there, your reports go to the Commission from a reporting mechanism. It's the same thing for the Financial Intelligence Unit. It's the same thing for the Public Procurement Act. So, Madam Speaker, today, 4 years later, absolute silence, no minority report, up jumps the argument that we need to look at the constitutionality of the authorized officers, because the minister appoints the board and the board appoints authorized officers. Madam Speaker, the provisions of the legislation are absolutely clear. The authorized officers, in exercising their powers, Madam Speaker, cannot go into premises where there is a refusal unless they are given a warrant from a court of law. And Madam Speaker, the precedent for that is to be found in the Financial Intelligence Unit Act. It is to be found, Madam Speaker, in the public procurement legislation. And Madam Speaker, permit me to put the public procurement legislation on the record. Madam Speaker, shameless opposition, 2x4 politics today, Madam Speaker, because they feel people don't do their homework. Madam Speaker, listen to what Section 43 of the Public Procurement Act says. Any officer in the service of the office and authorized by the regulator in writing may, for the purpose of conducting an investigation into any alleged or suspected breach of this act, examine, inquire, examine, take copies, remove, etc. Madam Speaker, what kind of serious member comes here today, having passed as a government then, the UNC government, the Public Procurement Act, where the same power and privileges exist in the Public Procurement Act, and today, no minority report, 4 years of silence, probably paid for, let me repeat this, probably paid for to all of a sudden embarrass the position of intellect in this parliament, Madam Speaker, because, Madam Speaker, how do you justify passing it in the FIU Act, passing it in the Public Procurement Act, and today the member comes up, well, you might offend the separation of powers, PSC principle, constitutionality, Police Service Commission. Today is an extension of the minister. Madam Speaker, what intellectual nonsense is that, Madam Speaker? Madam Speaker, let's go further, because, Madam Speaker, this debate will continue in and out of this House. Madam Speaker, what's the other point that the honourable members raised? Madam Speaker, increased penalties. Madam Speaker, had the members been courageous enough to even crack the spine of the Joint Select Committee report, bother to go into the offences section, bother to understand the import of the law, they would notice the introduction of the concept of lawful excuse. Sounds simple, simple enough, Madam Speaker. Lawful excuse is the method by which you allow people to defend themselves when they are met with an allegation of a crime. Madam Speaker, it is a wide-ranging softening of the penalty by affecting the intention to commit a crime element of an offense. And if the honourable members opposite cannot and will not understand that, well then, the Almighty ought to help us all out of that difficulty. So, Madam Speaker, it makes absolutely no sense for the honourable members to say that Senator Al-Rawi in 2015 complained about the excessive criminality when today we come with a modified version of the criminality. And, Madam Speaker, let me put it on record. The Joint Select Committee, for the 4 years that the UNC, and I can tell you this, Madam Speaker, if you look at the verbatim records, the member for St. Augustine agreed with, the member for Chaguanas West agreed with almost every single clause on the record. Exactly. Perhaps that's why Chaguanas West is not here today, I don't know. But, Madam Speaker, the verbatim reports will demonstrate full agreement. Couva South was in agreement, nodding head. The only person stout to the opposition cause was Senator Wade Mark. It's in the verbatim records. Who said, I need 2 weeks for Superior to tell me to sign the report, and 4 months later, nobody could sign report, Madam Speaker. So, Madam Speaker, let's get to the excessive criminality. Let's get to the point of, are there precedents for this? Yes, Madam Speaker, the Insurance Act, the Financial Institutions Act, Madam Speaker, what the member for Couva South did not read out, and I asked him to, but he stopped, was what I had to say to then Senator Hawaii as to the good work that we did in the Insurance Act, Madam Speaker, in ensuring that the penalties, which are in the millions of dollars, Madam Speaker, are managed appropriately. Madam Speaker, may I ask, what time is full time for me?
Your original time ends at 3:59:14, and then you'll be entitled to 15 minutes extended time.
Much obliged. Madam Speaker, let's get to the heart of what this bill is about. Because, Madam Speaker, the aspect of job losses is the only thing that I need to respond to in terms of the 4 points. Job losses. Madam Speaker, I was in the Senate of the Republic of Trinidad and Tobago sitting opposite a UNC government. An opposition senator stayed home, and a member employed by Mapao Casino came to the Senate.
Exactly.
They fill up the gallery with the whole of Mapao workers, and then they insisted that the 2015 law in June 2015 had to pass. They need this. The government have to pass this. Madam Speaker, I had the bill for 1 day. The independent bench noticed that it was inappropriate for the opposition and independent bench to have the bill for 1 day. We asked for a joint select committee, and I made certain observations which we have corrected in the bill today, Madam Speaker, in the amendments proposed. But Madam Speaker, I want to know what changed so drastically for Couva South and for Siparia, that in 2015, the entire position...
As the honourable member for Siparia.
Please proceed.
I wish to Mr. Speaker.
Madam Speaker, I would like to know what is wrong with the Westminster tradition. I'm perfectly in keeping with it. So, Madam Speaker, what has changed so drastically for the member for Couva South and the member for Siparia that in 2015 June, they could fill the whole parliament in Tawadi with Mapao casinos, and today, with a materially improved bill, 4 years later, international experts coming to the forum, documents in writing, Shagwanas West saying yes, Tabakit saying yes, Couva South smiling in the committee, agreeing with everything we had to say. Today, they roll him out to speak the opposite, but that's okay. Madam Speaker, what happened to say now today from Couva South that he reading a letter from Mapao workers? Madam Speaker, which is it? Support for the 2015 bill or support for the 2019 bill? Because the 2019 bill, Madam Speaker, only got better. Madam Speaker, let's get into what this bill does. Madam Speaker, I stand here before you today, speaking as one of the speakers on the government bench, able to tell you that the economy and the issue of crime are the two most significant issues in our society, as they have been for years. Madam Speaker, I stand here today able to say that as a result of aggressive reforms in the criminal justice system, the introduction of criminal proceedings rules, the creation of 3 divisions of court, the movement of judges from 36 judges to 64 legislatively, from 12 to 15 in the Court of Appeal. Madam Speaker, the introduction of a computerized environment, the introduction of plea bargaining, the introduction of judge-only trials, the introduction of 21 masters, soon to be 31 masters, from where we started at 2 masters, the creation of 125 courts by the time April rolls around this year. I'm able to tell you that trials can now be completed in 20 minutes in court, as is now the fact in Trinidad and Tobago. 2 weeks ago, Madam Speaker, Madam Justice Lisa Ramsumer Hines sat in a judge-only trial, a matter that was 18 years old, wounding with intent, rendered a verdict of not guilty in writing. 13 witnesses were heard in that matter.
Madam Speaker,
and the entire matter was done in 20 minutes flat.
48-1, please.
Thank you. Madam Speaker, people just get jumpy when they start to hear good news, you know, because it's the opposite of what the UNC is trying to apply in this country. So, Madam Speaker, in the context of this law, the criminal justice system stands into place. In the context of this law, what is this law asking us to do? Madam Speaker, in January 2015, bouncing glibly unprepared, Attorney General for the UNC walked into the Financial Action Task Force on-site review of Trinidad and Tobago. Nobody talked to the next person. The report comes out, we failed the review completely. And what does the Financial Action Task Force tell this country in its published report? It says, Madam Speaker, in relation to recommendation 20...
Your original time is now
If I may have the rest.
Please
Much
proceed.
obliged. They say in relation to recommendation 22 and recommendation 28, and in relation to the immediate outcomes that are relevant, that we have no supervision for private members' clubs. And as the IMF has said, Trinidad and Tobago is the only country under its observation in the pool of reporting facilities, the only country in the world with an economy of our size to have an unsupervised regulatory environment. Madam Speaker, in the Financial Action Task Force and in Trinidad and Tobago's anti-corruption drive under Prime Minister Rowley, the member for Diego Martin West, Madam Speaker, one of the largest areas for abuse, Madam Speaker, is in the private members' clubs. Let me explain to you why. The Financial Action Task Force produced a written report to say that the abuse that can be had with people walking in with the proceeds of crime, cash, let me explain it for the average person through you, Madam Speaker. A bandit walks into a casino. The bandit has $100,000 or $1 million in cash, buys chips at the table, gets to the table, and then says, you know what? I don't want to play. Takes those chips, gives it to his accomplice, who he wants to wash the money with. He walks out the casino. The accomplice walks up to the cash and takes the $1 million back. Transaction clean and clear, Madam Speaker. That is not my example, Madam Speaker. That's the example coming from the Financial Action Task Force. Madam Speaker, I can tell you as an attorney at law that worked for many years for the gaming sector, online gaming, overseas gaming. I can tell you as an attorney at law that worked with Interpol on doing international coordinated matters of regulation and seizure. I can tell you that the gaming industry is a multi-billion-dollar industry. It is so wealthy an industry that I can tell you right here in Trinidad and Tobago, one private members club rented a particular location for approximately $500,000 a month for a small location and stayed without occupation for approximately 7 years straight. And when asked why, they say that is less than 2% of our daily earnings, Madam Speaker. So let's talk real and ask the member for Siparia and the opposition why they are blocking this law today. And Madam Speaker, let me tell you this. The Financial Investigation Bureau, Madam Speaker, branch of the TTPS. Madam Speaker, I heard the PRO for the UNC making a most ridiculous submission in relation to the Minister of National Security and the Attorney General's office, saying, come with evidence of these proceeds of crime, talk about it. Madam Speaker, does the Honorable Senator know about the tipping off provisions? I know Siparia may not know about it, the Honorable Member. But Madam Speaker, the fact is that we cannot speak to these matters because we cannot be guilty of tipping off. We cannot be guilty of breaches of the law, Madam Speaker. But Madam Speaker, let me give you the typologies and evidence coming from the FIU, because we laid the report in the Parliament today. Madam Speaker, I can tell you, for instance, that cash seizures alone in a 1-month period, Madam Speaker, effectively, nearly 2-month period, have crossed already $36.8 million in cash, Madam Speaker. Cash, Madam Speaker. Cash seized under the Proceeds of Crime Act. I can tell you, Madam Speaker, that of the 17 matters for money laundering before the Trinidad and Tobago Police Service and that are now in court, there are many more matters behind that. I can tell you, Madam Speaker, that there are only 111 private members clubs registered with the FIU. Madam Speaker, did you hear Cooper South? I wrote down what the Honourable Member had to say. He said in his plea about workers, he said there were tens of thousands of workers who would be on the breadline. Thousands of bars, he called them watering holes. Madam Speaker, the Board of Inland Revenue recognizes that there are approximately anywhere between 5,000 to 10,000 amusement machines in Trinidad and Tobago. Madam Speaker, I don't know which private members club they're representing here today, but I can tell you, I know of the private members clubs that have those machines. And Madam Speaker, let's get to what the Board of Inland Revenue says. On the 111 entities that they supervise, they estimate $400 million in revenue for Trinidad and Tobago. Let me repeat this. 10,000 machines on the outside, 111 people registered. The Board of Inland Revenue cannot enforce the registration requirements. They cannot go in and audit, Madam Speaker, but this gaming law allows the taxpayers of this country to get their fair share from highly profitable enterprises in this country. And the only people standing in the way of that, with no minority report, with no commentary on the clauses, no mention of regulations, no mention of ministerial overreach, no mention of excessive criminalization, no mention of job losses, is the UNC. And today I call a spade a spade. Who business you mind in? The people of Trinidad and Tobago? Or a private members club that has contributed to campaign? Madam Speaker, let's talk brutal in this country. It is the money from crime that finds itself in casinos. It is the inability to monitor what comes in, to audit. It is the inability to have authorized officers go in there and check the taxpayers of this country. Madam Speaker, the right to life is the most paramount right in the Constitution. Today they tell us to protect job workers. Yes, we'll protect them by collecting taxes and make sure they're looked after. Yes, we have societal funds anchored in the legislation. Yes, we have a rehabilitative fund and a developmental fund. But Madam Speaker, the money from crime goes through the casino sector, and today the member for Siparia boasts a team, because the member for Couva South said on behalf of the opposition has a leader. The leader sits opposite. And the leader could not be bothered to tell her members to sign a minority report in 4 months. The leader could not be bothered to tell the Parliament that we had any observations. The leader could not be bothered to exercise that in the 2 weeks that Senator Mark asked. 4 months later, Siparia, the honourable member, comes to this Parliament leading off the member for Couva South, saying he's speaking for the opposition. Madam Speaker, you know what laziness is? You know what dereliction of duty is, Madam Speaker? It is the UNC, Madam Speaker. That is what this is. So, Madam Speaker, on behalf of the people of the Republic of Trinidad and Tobago, on behalf of the advocacy which the Financial Action Task Force has asked us to take seriously, which the competitive indices tell us we ought to take seriously, on behalf of the member for Chaguanas West, who must have absented himself today because he would have been too ashamed to hear the UNC in opposition, Madam Speaker. Maybe that's why St. Augustine is not here either, I don't know. On behalf of all of these right-thinking, sensible people in Trinidad and Tobago, we call the UNC's bluff. I'll tell you why. Nothing that they have said today is incapable of being cured at the committee stage. Nothing. The precedent for appointment of the people in the board, no big deal. We could borrow from the precedent in the civil asset forfeiture regime. We could borrow from the precedent in the public procurement regime. Easy stuff. 2, job losses, no job losses, job creation. The more regulated, the more people employed, the more money collected by taxation, the more prosperity in this country. Easy to deal with. Madam Speaker, when we get to ministerial overreach, we'll bring up the ABCs of constitutional law for the honourable members. We'll remind them of the classic cases that the Privy Council has handed down for us, and they will know by way of precedents in Trinidad and Tobago existing laws that that's a non-point, Madam Speaker. So, Madam Speaker, everything that you come here today to say, honourable member for Couva South, on behalf of your leader, on behalf of the opposition, Madam Speaker, why you couldn't say that in 4 years in the Joint Select Committee? The Parliament pays for paper for every member. The Parliament pays for computer ink for every member. The Parliament gives you a binder. The Parliament paid for an iPad for you. The Parliament gives you printed laws of the Republic of Trinidad and Tobago. The leader of the opposition has legal staff in the opposition. Members of Parliament have assistants. None are all here. Respectfully, could I get somebody to write a one-page and submit it? In 4 years and 4 months? Madam Speaker, dereliction of duty, slothfulness, laziness, ulterior motive, pretense, Madam Speaker. All of those are things that pop to mind to anybody listening to the counter-argument to the member for Couva South. Madam Speaker, they must know better. They must know why they wouldn't put it in writing. You know what's the easiest thing to do, Madam Speaker? Stand up and bramble. Do like somebody opposite who could only grumble and grumble and grumble, Madam Speaker, as opposed to contribute. You see, if it's put into writing, then you commit yourself to transparency. If it's put into writing, independent entities will get to understand the rubbish you are talking. Madam Speaker, that's why there's no minority report. Because you had to have a whole set of lack of shame to put in a report with the 4 points made by the member for Couva South, Madam Speaker. Madam Speaker, the Board of Inland Revenue says in 2017, they projected to collect gaming taxes for $250 million. They actually collected $58 million. For 2018, they projected to collect $281 million. They collected $79 million. The 2019, they proposed $103 million. They got $71 million. And here what the Board of Inland Revenue says. It says they need the private members' amendments. They need the law to compel this law to go into effect for the benefit of taxpayers. They say, Madam Speaker, that the recommendations are to allow for them to have multi-agency approach. They say, Madam Speaker, as a result of this government's multi-agency creation, in the period July 2019 to September 2019, in 5 private members' clubs alone, they were able to receive and recover $29 million in taxation. Let me repeat that. In a period of a couple of months, June 2019, Madam Speaker, to September 2019, sorry, July, August, September, in a 3-month period, as a result of the police working with the Board of Inland Revenue, Madam Speaker, they were able to recover gaming tax liability of $29 million, Madam Speaker. Madam Speaker, what's the real game the UNC playing here today? Who they really batting for, Madam Speaker? What is being hidden, Madam Speaker? What is not being said, Madam Speaker? How do you explain 4 years and 5 months, 4 months of silence? How do you explain no written minority report? How do you explain trucking in MAPAO workers and bringing them in as a temporary senator in June 2015 under Siparia's government? And then all of a sudden coming to say, well, them same workers that were supporting the unamended bill, they're going to protest. Sound fishy to you? Madam Speaker? Something don't add up. Something just doesn't add up, Madam Speaker. So, Madam Speaker, oh yeah, there are a few lockups to come, Madam Speaker. Siparia asked it. So, Madam Speaker, that's the job of the TTPS. And the Trinidad and Tobago Police Service will do, no doubt, what they need to do. The Honourable Member for Couva South asked if there's going to be a specialized unit by the TTPS. Yes! It's been formed already. It's a combination of the Cybercrime Unit, the SIU, the Anti-Corruption Investigation Bureau, the Fraud Squad, and the Financial Investigation Branch. They're up and running. They're hard at work. They've been doing it for over a year because this government returned the ACIB to the police because we didn't want to be like anyone else. Madam Speaker, everything raised by Couva South can be dealt with at committee stage. The line is drawn here today. Let's get on with the people's business. I thank you.
Member for Oropush East.
Thank you very much. Madam Speaker, I appear to be more popular today than before. Don't know why. Madam Speaker, thank you very much for the opportunity to contribute on this very important measure before us. And to begin by stating that it is not my objective to be unduly loud or hostile. It is not my objective to boof anybody opposite me on this matter and to accuse anyone of any ulterior malice or ill-conceived motives, but rather to respond to some of the issues raised by the member for San Fernando West, who himself was quite loud, unduly disturbed and frustrated. And I have a feeling that may have to do with the announcement last Sunday. Because, Madam Speaker, for cricket lovers, his fate is that of Malcolm Nash in 1968, who Gary Sobers slammed for 6 consecutive sixes in an over. And I'm afraid the member for San Fernando West, like Malcolm Nash, will be on the receiving end of some strokes from a Sobers. So he was unduly frustrated and angry today, and it may well be that that has to do with matters external to this debate, and that has to do with matters external to the bill. Madam Speaker, I just want to deal with a couple of things quickly because I don't want the member for San Fernando West to succeed in confusing the national community as to what we are doing here today. And I don't want to repeat either statements made by the very, very eloquent and powerful presentation from the member for Couva South. Himself, I believe that the member for Couva South attended more meetings of those joint select committees than the member for San Fernando West. So if the member for San Fernando West could not understand Couva South, it was really because the member for San Fernando West may not have been present at those meetings of the Joint Select Committee. Madam Speaker, I have in my hand a one-page note. Madam Speaker, it is, and I quote, Minority Report of the JSC on Gambling, Gaming and Betting Control Bill 2016, dated 24th of June 2019. And this is a minority report submitted by Wade Mark, member, Ganga Singh, member, Rudranath Indarsingh, member. And if you do not have it before you, you should blame the postman. You should not blame the members who authored this and have it signed on the 24th of June 2019. And I have it in my hand. But you know, you should not gallery that you don't have the minority report, you don't have it. Clearly, you made no attempt to get it, as I did. Clearly, you wanted to come to gallery that it is not in the book. And Madam Speaker, it reminded me of other joint select committees before, and I want to predict joint select committees in the future under this short-lived government. You know, because what they do is they hustle members, generally. They hustle you by coming overnight with a report and have members of the opposition now coming on the morning when they are presenting and say, we intend to present this report. You have meeting, you have minority report, yes or no? And when you say, look, we have to caucus, we have to put our heads together, we have to write, we have to type, we have to print, and a half an hour will not be enough to do it. They come and they circulate a report and say, look, you didn't append it, you didn't put it into the secretary on time. But between June 24th, 1919, to what is the date today? 7th of February, 2020, surely you had enough time to get your hands on a minority report. It is there.
Majority report was in September.
And if you look to the majority report, you will see that Senator Mark, Member Singh, and Member Indarsingh did not sign that report. So if they did not sign that report, that means they did not agree with you. And if they did not agree with you, clearly, they would have a minority opinion that will be reflected in a report. So what was the big deal What you shouting and crying and bawling for the last 2-3 hours? When you have this available to you, and you're quarreling that it is not in the book in front of you. Could I just make about what, 2 or 3 copies and give you? It's 1 page. 1 page. The Parliament could give you that. So I have in my hand the issues raised in a minority report, which the government refuses since June to February to get a 1-page document. And look at this here, 24th June. What is this, a fake? If it's a fake, report it to the police that this is a fake document. But member Indarsingh has said that they submitted a minority report, as we did with the Commissioner of Police matter, as we did with other matters before us here. And it is here. So it deals with regulations and so on. I'll get to it because it's a very important matter. Madam Speaker, the member for San Fernando West asks, what side are we on? Who are we standing up for? I want to indicate to him we are on the side of the workers, we are on the side of the industry, we are on the side of the companies, and we are on the side of Trinidad and Tobago. If it is that you have to pass this to get some approval outside of Trinidad and Tobago, and you want to pass it today, and you want to bully the opposition, then say so. Say you want to come today and bully us because you have people waiting in Geneva or Brussels or Paris, and you told them by 12 o'clock Trinidad and Tobago time it will be passed. So you could say that, but don't come today and ask us what side we're on. We're on the side of the people, as we have always been. Madam Speaker, so that minority report, let me put it to rest. If you don't have it, it's because you don't want it. And if you don't want it, say so. Madam Speaker, there was a reference to an important report, this report of the decisive expert report on the regulations and so on. It was before the committee, I believe, Governance Associates. And they praise and thank the people there and so on. Madam Speaker, I just quoting from the report. They say, they are saying, having considered the drafts, we offer the following overarching comments. They provide a workable foundation for the new regulatory scheme. We would recommend that the settled regulations, what settled regulations mean? Anybody know? It means it's settled, it means it's fixed, it means it's final. It means we are not going to be, changing, it is settled. Those regulations be the subject of consultation with the industry to ensure there are no unexpected issues. Now, when an international community, international company like this talk about unexpected issues, you know what they're trying to say? Don't try nothing fishy, no. Don't try nothing. Settle the matter first, and don't change your mind. Now, why would a big company like this, paid, as an external consultant and well respected, tell the PNM government, we hope they have no unexpected issues? Because they probably have a dossier that speaks about you already. They probably know that you have failed to give effect to the procurement legislation. They know that. They know that Lalchal Moonilal, no relation, have been complaining for years that you have not approved regulations. They know that the procurement regulator have been complaining. They know that the construction industry have been complaining. They know that the opposition have been complaining, of the DPP and others complaining about your failure to give effect to a bill passed in 2015. So having that knowledge, they say we don't want no unexpected issues. What is so wrong with you finalizing the regulations, taking it to the stakeholders, getting their buy-in and coming to the Parliament with the regulations? What is that? Why you can't do that? You want to pass a bill because you want to satisfy external agencies and so on. Fine with that. Bring the regulations. That is what the minority report says. Regulations. We have the firm view, they understand. How can we support and associate ourselves with a report unless the regulations are seen and ultimately sanctioned by the Joint Select Committee? So there was a call for the Joint Select Committee to see and sanction those regulations. They have failed. They have failed terribly to do that. Today we're debating that matter, Madam Speaker. You see, in this matter, we are informed that those regulations could be extremely onerous. And I will come to that now. Somebody sent me on my telephone just a couple minutes ago, Madam Speaker, what appears to be employment forms. They are going to impose a licensing framework. And Madam Speaker, everybody in this business here, if you are a car park attendant, you're cleaning the floor, you bring in coffee and tea, you're taking money, you're giving chits, you're giving whatever they call themselves giving there, you have to have a license. 25,000 people might need a license in this country. They give out, they specify in the bill all, that they have to do, fit and proper and so on. We'll get to that. Someone sent me, in this industry, sent me a note just now, Madam Speaker. Madam Speaker, do you know that in filling out employment forms in this sector, filling out the forms and so on, you have to put, this is what they were proposing, but they have not settled, because they can't settle, because if the workers and the employers and the organizations know what regulations they may be coming with, they will not support this bill. As much as it is needed. We have never said that this bill is not needed. Madam Speaker, you have to list your name, your residence addresses, date of birth, most recent occupation of parents, parents-in-law, former parents-in-law, guardians living or deceased, if retired or deceased, list address and occupation. So, Madam Speaker, when you have in-laws and they become former, you don't want to go back. Madam Speaker, that's why you're no longer in-laws, because you don't want to go back to check what was the work, what was the occupation of your former in-laws. Madam Speaker, this is what they are proposing to do, to create a regulatory environment where ordinary workers, Madam Speaker, men and women out there, eking out a living, Madam Speaker, would have to apply and be granted a license. And Madam Speaker, in this licensing regime that they are proposing, there's gaming operators, gaming owners, bookmakers, promoters, machine operators, machine distributor, technical operators, premises license, personal license, gaming machine license, and any other license, which means you can create another one, Madam Speaker. Given the number of licenses that would be required to operate in the gaming sector, the cost for obtaining such license, the rigid fit and proper criteria, there's a fit and proper criteria, Madam Speaker. Let me get to that quick. Clause 41, I believe. It is mandatory that every applicant for a license must be assessed subject to fit and proper criteria, Madam Speaker. This is an onerous requirement when one considers that many of the persons referred to as requiring a license will not meet your fit and proper requirements. Madam Speaker, the criteria under the Financial Intelligence Act, financial institutions are in an identical position to casinos with regard to money laundering and terrorist financing. If that underlying assumption is adhered to, then the requirements for fit and proper ought to be the same, and the classes of persons to whom it is required should be the same. Madam Speaker, it is not the same in this matter. So saying that you have these criteria and rules and regulations for other sectors in the financial arena doesn't work for this sector, because there's a different body of people, Madam Speaker. Madam Speaker, 99.9% of the staff of financial institutions are not required to be licensed, but this bill is demanding, in effect, that all the staff at a casino should be licensed. What is that about? So in the financial institution, a few people, key people and so on, may need license, but in this, everybody, the car park attendant, the person by the window collecting the money and so on. And I heard the member talking about people taking money in casinos and bars and so on and using it to launder. Madam Speaker, in those business, in that area, you need ID card, you need bank account. It is governed by anti-money laundering laws and so on. So it cannot happen like that. Madam Speaker, they speak about financial soundness. This is vague, uncertain, lacks objectivity. Adverse findings in terms of your criteria. Madam Speaker, that is extremely subjective.
What is the minimum evidential threshold for honesty and integrity that Schedule 2 F&G speaks to? This is what is required. What you need, a certificate of good character. One, you need what else? Banking institutions, certificates and so on. Madam Speaker, they are telling us now that when as MPs we meet people, nobody should come to our office unless they have a certificate of good character. So we cannot meet people as members of parliament who want to see us because we need to see a certificate of good character. That is where they reach. And that is where they are taking this country along a line of excessive and burdensome and distressful regulations that will lead to mass unemployment.
Okay, so honorable members, it's now 4:30. We'll take the suspension now. We shall resume at 5 o'clock. This house is now suspended.